listed day after tomorrow, my lord. Fresh, day after tomorrow.
May it please your lordship. So far as item number 6 is concerned, I beg to withdraw with a liberty, my friends, on there. It's for the other side.
We as conic learned count for the petitioner.
Under instructions.
Submit that he has instructions to withdraw this petition with the liberty full stop. Also heard 3 so that it counts for the number 1. Full stop para. Petition is accordingly dismissed on with liberty.
May I further give indulgence, my lord? Insofar as item number 17 is concerned,
Yes.
I have checked that it's only that the records have come and the matter should be fixed for hearing.
Hmm.
I've also told Mr. Ghosh, SK Ghosh for the other side.
Yes.
I'm not keeping well, I'm having some heel problem, So therefore, if lordship would accommodate-
17 matter.
17. 2000, no, item number 17,
Okay.
10 matter, only it should be fixed for hearing. I've informed Mr. Ghosh. My slight difficulties, my lord.
It is submitted that the matter has been admitted
Yes,
and answer has come. Full stop para. Please for hearing in its court.
obliged,
It is turned. Item 17.
grateful.
May I please your lordship? Lordship, for item number 7, it's a maintenance appeal matter, and we have received instruction from our client that both the parties have come to a settlement, and settlement process is going on. So, lordship, another date may be fixed for hearing.
You are for the petition,
For the petitioner, your lordship.
your S. Kashyap,
Yes, S. Kashyap, Shamanta Kashyap.
3 S. Kashyap Learned Counsel for the petitioner submitted that there is a talk of compromise going on between the parties and the matter is likely to be settled. Full stop para. Para. He accordingly prays for some time. Para. Other side informed
Yes, yes, your lord.
in that view of the matter, list of the 6 weeks.
It's 6 weeks.
Mr. Sayala? Also,
Yes,
also,
to be settled.
also to GN Sayala Learned Senior Counsel for the respondent. 6 weeks. Yes.
Deeply obliged.
May please lordship, this matter lordship IAC bill. It may be listed for order on 26. Matter relates to release of the amount deposited by the insurance company.
Obliged.
I beg to mention item number 11, my lord. This matter may be adjourned, my lord, for 2 weeks, my lord.
On the prayer of Priti Islam Learned Counsel for the petitioner, matter is adjourned by 2 weeks.
My lord, I'm mentioning a first appeal, my lord, for listing it for order on 2nd of August. So the last listed in 2019, my lord. Some urgency.
Of which year?
2019, my lord. Obliged.
May I please your lordship, my lord, the MSC appeal matter, it is settled outside the court, my lord. Let the matter be listed on 26 for orders.
When to withdraw?
Yes, it will be, only order is required. Matters settle outside the court.
That means it has to be withdrawn.
Yes.
Lordship, case number WPC H24 2022. Service matter to pay for an early hearing.
This is not the bench. We are having bench one. You have to go to the bench 3.
May I please, your lord. My lord, with the consent of the other side, I beg to mention item number 54, my lord. Kindly pass over for the day, my lord, because my lord, my senior is out of station, my lord.
Inform the other side.
Yes, my lord.
You are for the petitioner.
Applicant responded. I am for appellant opposite party, my lord.
That is it. You are for a prayer has been made on behalf of the respondent. IA for what?
I have for injunction, my lord. Injunction granted, I have filed objection, my lord.
You are the appellant.
Appellant, my lord.
A prayer has been made. A prayer for adjournment has been made on behalf of the appellant. Full stop. List. So after a week,
Yes, my lord.
list after a week.
Interim order may be complete.
Interim order passed earlier. To continue till the next date of listing.
Most obliged.
My pleasure.
Just a minute, you are for the appellant, aren't you?
Yes, my lord. I am for appellant. Appellant,
There is an injunction.
they filed injunction petition, my lord. Injunction granted. I have
The
filed.
respondent has filed injunction here in this,
Yes, my lord.
in the
Yes.
appellate state.
Yes, my lord.
Injunction is granted.
Yes, my lord. Most obliged.
My pleasure, Your Lordship. I beg to mention item number 9, Your Lordship,
Yes.
with the consent of other side, Your Lordship. Lordship, my prayer pass over the matter for the day, Your Lordship. Any date, Your Lordship,
On
for
the
that.
prayer of the AR Kadima. Is the prayer. I conflict for the petitioner. Okay, for number.
Interim order pass earlier shall continue.
Interim.
Oblige, Your Lordship.
With your lordship, with respect to item number 8 of your lordship daily list, my lord, some talks of compromise is going on. I have been instructed as regards that, my lord. So sometime maybe.
Right,
I have to obtain inspection for my party.
18 matter, we'll grant you a week's time. Initially, then if there is a bona fide item, then we'll probably extend. 2 weeks,
2 weeks, 2 weeks.
3D goes counsel for the petitioner submit. That there is a talk of compromise going on. Full stop. Also, our AK right. Then counsel for respondable 1 and 2, full stop para. In the interest of justice, please stop at 2 weeks.
I'll use that.
May it please your lordship. I'm praying for listing of a matter, lordship. There is urgency, lordship, for tomorrow, civil revision petition, lordship.
What is the urgency?
There is urgency, lordship. Matter is relating to child custody, lordship. And it is again fixed on 28. That is why
What
there
is
is.
the urgency?
No, lordship, matter is fixed for judgment without hearing the petitioner, lordship. That is why, lordship. And regarding custody, child custody, minor child.
At this stage, can we interfere?
Yes, lordship, there are several petitions we have filed and all the petitions were rejected without hearing.
Are those the subject matters of challenge in this revision?
Yes, lordship. On 20 July, we have filed one review petition that is also rejected. Earlier, 23/6, we have filed that was rejected. 6/7,
Now, what
we
is
have
going to
filed.
happen if the judgment is passed?
No,
what is the
lordship,
urgency?
custody matter is there. If custody is given to another parent, the father, then the child will be, lordship, suffering. The custody from the mother will be taken if the judgment was passed that way,
How
lordship.
old is the child?
Lordship,
How old is the child?
child is 11 years.
He goes to the father, there'll be a problem.
Yes, lordship, he is with the
Sorry.
mother since birth, lordship.
Sorry. No urgency. It will come in its turn. Yes,
May I please, lordship?
judgment is yet to be pronounced. You are preempting a court to pass a judgment. Is that the attitude?
No, lordship,
Then
that is not.
how can you
the-
preempt a court from passing a judgment in judicial exercise of power?
Lordship,
No.
child will suffer, lordship, kindly.
Child suffers with a father.
No, see, he is with the mother since
So if
his
he
birth.
goes to the father,
lordship.
he'll suffer. Which
Yes,
not
lordship,
true.
if the
Well-
custody was taken from the mother, lordship,
Which not-
kindly, lordship, day after tomorrow, lordship.
Sorry, it will come in its turn. Yes,
Lordship, with the consent of the other side, I beg to mention item number 12, lordship.
yes.
It may be come up on the next week, lordship, along with CRP number 7923, lordship. Both are analogous matter, lordship, arising out of same execution proceeding, lordship.
The execution proceeding is the same.
Yes, lordship.
When do you want this matter? Day after tomorrow,
Next week, lordship.
next week.
Along with
What is the number?
CRP number 7923, lordship.
Other side has been informed.
Yes, lordship. We have taken.
I'm for a respondent.
Your name?
Yes, that's lord.
3 years, just learned counsel for the petitioner. Submits that there is an analogous petition. Being CRPIO 79 of 2023. Full stop. Para. List after a week. Along with
Interim may be continued.
along with CRP number 279. Para. Interim order passed earlier to continue till the next day.
Lordship, date can be fixed, lordship.
Tell us. As agreed to by the parties list on. Hello.
Third of August,
No, third will be the Thursday. We'll have it on 7th of August.
7th of.
7 August.
I love.
May
Yes.
it please your lordship, it is for listing of a CRP for withdrawal, lordship. It will be listed on 26 lordship.
Obliged.
May I please your lordship, I beg to mention item number 62 of supplementary list.
Hmm.
My lord, may it be taken at 2?
It's two. This is top of the list.
Yes, my lord.
Elementary education, who's there? At 2 o'clock? Today, second half.
Other one portal has at 3:50. Some other day, madam.
Hmm?
Some other day, madam.
Tomorrow?
Madam.
But today, we have some interviews also. These days we have to rise early.
Then my lord, may it be fixed on a short date?
We'll have it there tomorrow. We'll try tomorrow. Tomorrow first item.
Madam.
But be there.
Madam.
Obliged,
Hmm.
lordship.
A prayer for accommodation has been made on behalf of the petitioner. Full subpara. Considering that this matter has been listed under the column top of the list, list again tomorrow. But be there. We should not search for you.
May I please, your lordship, I beg to mention item number 18, lordship.
Yes.
Lordship, engage council out of station, lordship. Your lordship, 1 week time may be granted, lordship. Item number 18.
You have informed the STC.
I am the applicant, lordship. I am.
Have you informed the STC?
No, sir, no.
You have to inform the STC. Without information, one on the passport. Yes. Next.
May I please your lordship, with the consent of other side, I beg to mention item number 10.
Yes.
Matter may be taken up after 1 week.
You for whom?
And for respondent,
What is your name?
actually I am not engaged counsel.
Doesn't matter. What is your name?
Januddin.
You're with Mr. BKSN. Others had informed.
Yes.
Januddin letter counsel appearing on instruction of the BKSN letter counsel for the respondent. Praise for an adjournment. Put the list after a week. 1 week.
May it please your lordship. Lordship, I beg to mention for listing of a new CRP IO lordship. Already well filed on 20th of July, lordship. Can it be on 26th, lordship?
Motion.
Obliged. Motion matter.
May I please your lordship? Lordship, I beg to mention one MFA for listing in hearing, my lord.
It will not come up for hearing. It will come up for orders. MFA of which year?
My lord,
MFA of which year?
2016, my lord.
You give the mention memo, it will come up for orders day after tomorrow. We'll pick over here.
Yes, my lord. And
LCR
matter may be fixed,
LCR has come or not?
my lord.
LCR has come or not?
I don't.
Lower courts records have come or not?
Yes, my lord.
Give the mention memo for Wednesday orders. Two writ petitions and one contempt.
My lord, my lord.
You were a respondent in one, petitioner in the other.
No, my lord, we are the petitioner. Yes, my lord, I am the petitioner in WPC 3723 of 2022, my lord. And my learned friend has preferred two petitions, my lord. And that is also a part of the record, my lord. My lord, the issue is as regards, my lord, provincialization.
Why contempt against you?
My lord, actually contempt, I think it has served the purpose, my lord.
Where file contempt because there was a stay order. Lord. Right of that, lordship, the respondent, the petitioner in item number 1 was contempt against the principal. Ultimately, lordship, contempt was filed and thereafter
Removed,
has
my
been
lord.
removed from the post provincial.
Contempt has become, my lord, now infectious, my lord, basically as the order has been complied with, my lord.
Now, the main issue is about.
My lord, the main issue is that, my lord, I had been, my lord, provincialized as a tutor principal of Sontoli Anchalik College, my lord. My lord, the government, my lord, has decided a policy that in those colleges, my lord,
Just
my lord,
we are proceeding for what today?
my lord, can be disposed of, my lord, because I am without salary, my lord, from so long, my lord.
Yes.
In our matters, till that they haven't filed their affidavit. Lordship. More than a year has passed. We are praying for appointment.
Higher education.
Notice was given in the month of December 2021.
Yes. Mr. Das,
My lord, affidavit has not been filed, my lord, by us.
affidavit.
Sorry, my lord.
You have not filed affidavit.
No, my lord, if some time may be granted, my lord.
These are matters on the top of the list.
Lord, my matter can be
The,
taken up, my
the
lord.
entire objective is to have an expeditious disposal.
My lord, basically the grievance which my learned friend has raised, my lord, the in-charge principal has been given to some other college principal, my lord, as a interim measure, my lord. That arrangement, perhaps my learned friend has not yet challenged, my lord. Now he is claiming that I should be given the in-charge principal, my lord. That has been defied by the department, my lord, because as there is a chaotic situation is going on. I have been also relieved and he has also not given, and it has been given to a third party, my lord, a principal of another degree college, my lord. So, my lord, that order is required to be
Mr.
challenged.
Das, you have the instructions or not?
Not received, my lord, yet.
Why? Is it proper on your part to come and say no instruction received of matters of 21 and 22?
My lord. So, challenge for me.
We had granted time on the last occasion, 19/6/2023. You have not bothered to file affidavit. Last opportunity of 1 week.
My lord,
Last opportunity. We'll take it the Monday next.
10 days.
No, not 10 days. We have given enough time. If you do not file, you lose your chance. Third, 3, ARP here, and it counts it. And for the ARP here, comma. Your name?
A Chakraborty.
A Chakraborty. And a Chakraborty Learning Council for the contesting parties who have filed separate writ petitions. Also heard 3, as does current council for the higher education department. Anyone? 3, as Vishwakarma has appeared for response number 3 in WP 372/2022.
On the last occasion, I had prayed that I will be filing an affidavit, but it seems I will not be required to file an affidavit.
Para. These matters are pending since the years 2021 and 2022. And on the last occasion, comma, further time was granted. No, last occasion, wide order dated 19/6/2023, comma, further time was granted to the official respondent to file affidavit in opposition. Para. 3 does the understanding council, however, submit that instructions are yet to be received. Para. This court is of the view that matters cannot be adjourned in the manner only on the reason that instructions have not been received. Para. Therefore, in the interest, however, in the interest of justice, comma, our last opportunity is granted to obtain instructions, plus file affidavit in opposition, whereafter these courts would proceed in accordance with law. Para. List on. We'll have it on. Okay, we'll have it on. We'll have it on 2nd of August.
my
We get more than 10 days. More than 1 week. 2nd of August. Wednesday.
Maybe a good lordship.
Yes.
On the last occasion, my lord, the learned council, standing council was, my lord, directed to produce records, my lord. The petitioner was appointed as the president of the.
Yes,
SMDC.
my lord, record this. What does it say? My lord, record said, my lord, initially, my lord, the respondent he has selected, my lord. Subsequently, on the verbal order of the deputy commissioner, that has gone. And thereafter, my lord, deputy commissioner recommended, my lord, second person, my lord, not the petition. That is the record, my lord. Some modification order was there, my lord. This is the president of SMDC. My lord.
My lord. Higher secondary school, my lord.
My lord will find in the first section, my lord, that is the notification. Yes, anything you are saying? Which part? My lord. First annex is, my lord, notification, where a process for initiation of the SMDC president and vice president. Annexure of the record. Records, my lord. Annexure A. Annexure A, my lord. 27 June 2016. This was the earlier notification. My lord, earlier notification. Yes. Subsequent, my lord, one notification issued, my lord, where deputy commissioner was empowered to nominate. Yes. My lord. That one is annexure 2, my lord. Yes. And guardian minister, my lord, on 27 October 2021, my lord, another provision was also included where approval of the guardian minister is required, my lord. Yes. Next, my lord, initially, my lord, name of the petitioner was forwarded, my lord, we find it annexure 3. Next page, my lord, serial number 58, my lord. Jafar extended higher secondary school. Let us see the discussion where his selection was done by the deputy commissioner and approval was done by the guardian minister. My lord. Because the notification as such is not the subject matter of challenge. My lord. Where is that part? My lord, that part, my lord, that approval, second part, my lord, approval was not. No, regarding selection. My lord, annexure 3. Annexure 3, my lord, second page, my lord. What is your name? Anirveda.
My lord,
Anivana. Anivana Datta. And the respondent?
Bikramjit Datta.
In annexure C, Anirvana name is there. My lord, initially his name was approved. Okay, then? Then, my lord, subsequently, on the order of the deputy commissioner, my lord, additional deputy commissioner, education, my lord, next annexure, my lord, D. Reconstitution. My lord, 6/6/2022. Yes. That is reconstitution, my lord. Subsequently, my lord, this is some application, my lord, submitted by person, my lord. Annexure Z is relevant, my lord. Z, my lord. Yes. Annexure Z, 29/2022, my lord. Bikramjit Datta, president, and Pradeep Shukla. Yes. Partial modification of the office earlier notification issued by so 6/4/22, where my lord petitioner was recommended, my lord. Name of the president and vice president constituted of the school managing and development committee of so higher secondary school, so below. Guidelines necessary approval of the deputy commissioner, my lord. Bikramjit Datta, president, and Pradeep Shukla, vice president. Both person, my lord, their performer also submitted, my lord. There is a discussion.
My lord, there is a letter
There is a
on
discussion.
second.
Arulda,
My lord,
that initially though there was a notification
my lord,
by which your client was made the president,
my lord,
but that had to be reviewed because there was a prior petition made by the local people and the suggestion was also taken from the principal of the school.
my lord.
Those were considerations whereafter the private respondent has been favored.
My lord. Now, my lord, your lordship, I can see page number 25, my lord. The notification by which I was appointed as the president of the higher secondary school, my lord. I am MA, BEd and PhD, and I am a professor, assistant professor of a government college, my lord. And my lord, the same notification is appointed 76 other presidents of other 76 high and higher secondary schools.
These are all discretionary things.
My lord,
This is only the SMDC president. It is not a post of lecturer
my
or
lord,
professor,
my lord,
where a qualification would be
my
very
lord.
much relevant. It may not be relevant.
Now, my lord, the other remaining 76.
Unless you tell us the notification, giving the power to the deputy commissioner.
My lord, in my notification also, my lord, in consultation with the deputy commissioner, I was appointed, my lord.
Understood. That has been reviewed and there are reasons in the file. We would not like to interfere with.
My lord, moreover, my lord, the other presidents of 76 schools are continuing, my lord. They are also appointed by the same notification. They are continuing with the
The
respective
whole
post.
notification has not been cancelled. The notification pertaining to you has only been interfered with.
That
is
is
not
not
a reason.
arbitrary, my lord, because other
It
political.
has been arbitrary if there was no reasons. Reasons have been expressed, has been written here. It is backed by whether those reasons are sufficient or not, will not go. These are all discretionary matters, and we will see whether the notification has been followed or not. It appears to have been followed. Madam, anything by it? Yes.
As per my information, some complaint was lodged by the local public and they preferred the respondent number 6. Subsequently, this modification has been done and accordingly, Lordship, here the concept of political pressure which has been brought, but this is prima facie only statement, Lordship. Nothing has been proved that I have used any political pressure or something like that. And as per the requirement, graduate candidates, as per the notification, which is I have annexed also in my affidavit, graduation is enough for, and the respondent number 6 is also involved in social activities, Lordship. And one document I have annexed, where in the affidavit filed by the respondent number 5, that is annexure 8, page 56. First meeting that was held, local participants, 134 candidates of the local people supported me and nominated me as president. Subsequently, Lordship, after modification of the earlier notification.
And this modification has been done only in relation to this particular school, my lord. That is the problem, my lord. And my earlier, my lord, your lordship, I can see page 28 of my petition, my lord.
That is not a point.
My lord.
You establish your ground. One part of this notification may be a common notification, but it touches upon many schools. One school has been touched. That by it cannot be a reason for interference. You have to come up with some definite ground.
And my lord, also against this, my lord, replacement. As many as so many people from the locality, my lord, have also submitted representation to the deputy commissioner, my lord, saying that this president should not be replaced by the respondent number 3. Well, he is an educationist, my lord, professor of the department, and the respondent number 6, my lord, who has been brought to the picture, my lord, by the subsequent notification, my lord, is a businessman, my lord. He is running the clothes house, my lord.
My lord, but he's a graduate.
He has
And I have
he has no
annexed the
connection with the
documents,
education, my lord.
As per the notification, it is enough.
In your writ petition, you have not annexed 2710,
My lord, 2017.
2021.
It is not there, my lord.
The notification presently holding the field 2710.
7, 9. My lord, it is not here, my lord. 29, 9, 21 is there.
2710 is not a partial.
That is, has it been annexed to the writ petition? Have you mentioned about that notification in the
Not, my lord.
not mentioned? Just check. Yes. We will dispose this. When this matter was taken up by this court on the last occasion, the following order was passed. Please take a pura order. Huh? Pursuant to the state order, the record in original has been produced by the P. Sekia, Learned Standing Council. Here for the government, sorry. P. Sekia, Learned State Council, appearing for the state respondent, including the Deputy Commissioner of which district? Karimganj. Pre Taluda, the Learned Council for the petitioner has submitted that by the initial notification dated 4/6/2022, as SMDC of as many as 77 numbers of schools
My lord.
were constituted, and by the impugned order, only in impute order dated 2/9/2022, change was brought only to the school of the petitioner in question,
My lord.
whereby the petitioner was replaced by the respondent number 6.
6, my lord.
Terming the said action to be arbitrary and unreasonable, he submits that there are no cogent reasons for issuing the impugned notification, as the earlier notification was issued by following the guidelines contained in the notification dated 24/6/2016 pertaining to constitution of SMDC. Full stop. It is further submitted that the petitioner is an educationist and better qualified than the respondent number 6, who is a businessman. Full stop. Per contra, we take care that the state council has submitted that while the petitioner has annexed the notification dated 24/6/2016 by submitting that the same is operative for constitution of SMDC, the factual position is a different one. Full stop. He submits that presently a notification dated 27/10/2021 is holding the field whereby the deputy commissioner of the district is empowered to select the president and the vice president of the SMDC of an educational institution of the concerned district with the approval of the guardian minister. Full stop. He submits that the impugn notification dated 2/9/2022 has been issued by following the notification dated 27/10/2021. Full stop. By referring to the record, comma, the state council submits that the same contains the reason for which the impugn notification was issued. Full stop. Para. MSS Dasgupta, the counsel for the response number 6,
5
Five.
and 6. 5 and 6.
5 and 6, by controverting the submission made on behalf of the petitioner, submit that and contends that the present notification dated 27/10/20, notification dated 2/9/2022 has been issued in accordance with law and by taking into consideration the relevant facts and circumstances. Full stop. She submits that the response number 6 has got the requisite qualification to be appointed as the president of an assembly. And and there is no requirement to possess any higher qualification as contended on behalf of the petition. Full stop. She further submits that it is the mandate of the local people and the views of the school authorities which would be material. And in this case, the response number 6 appointment is back, is decayed by both the aforesaid factors, which are the only relevant consideration. Full stop. The learned council also endorses the submission of the Saikia, the learned state council, by submitting that the present notification holding the field dated 27/10/2021 has not been challenged. Full stop. Para. The rival submissions made by the learned council for the parties have been duly considered, and the materials placed for this court, including the records in original, have been carefully perused. Full stop. Para. The principal ground of challenge, as would appear from the repetition, is that by the initial order of appointment of the president and vice president of SMDC of various schools by the notification dated 4/6/2022, 77 numbers of schools were involved, and by the impugn notification dated 2/9/2022, only the school of the petitioner has been affected. Full stop. This court, after perusal of the record, have seen that before the impugn notification was issued on 2/9/2022, there was a consideration to the relevant factors. Full stop. The records reveal that there was a prior petition from the local people of the school, and a suggestion was also received from the principal whereby the response number 6 was favored. Full stop. This court has also taken note of the fact that presently the notification holding the field for appointment of President and Vice President of SMDC is the notification dated 27/10/2021. Full stop. The state notification for the sake of convenience, the state notification is expected here in below. They are expected here. By the aforesaid notification, the power to select the president and the vice president of the SMDC is vested upon the deputy commissioner of the concerned district with the approval of the guardian minister. This court has also noticed that the great petitioner has chosen not to challenge the aforesaid notification dated 27/10/2021, and in fact, there is not even a passing reference to the state notification in the entirety. The record, as recorded above, as observed above, contains reasons for issuing the impugned notification dated 2/9/2022, and the reasons appear to be germane and relevant. This court, in exercise of powers under Article 226 of the Constitution of India, is not required to evaluate, to go into the merits of the decision, and only the decision-making process can be a matter of scrutiny, and in the instead case, the decision-making process appears to be just and reasonable, and in accordance with the requirement of the notification dated 27/10/2021. This court has also said that the minimum qualification for a president of an SMDC is graduate, is to be a graduate, and the response number 6 fulfilled the same. In view of the aforesaid discussion, this court is of the opinion that no case for interference is made out, and according to the interpretation, the records are handed over back to the learned formal counsel.
One thing, my lord, the notification dated 27/10/2021 was in operation at the time when I was appointed, my lord.
Yes.
That was also in operation, my lord.
That was an operation. We have not said it's not an operation. You could annex 16 notification. Why haven't you annexed this one?
May I please, Your Lordship?
Yes.
My lord, the instant appeal, my lord, first appeal, my lord, against the order dated 4/7/23, my lord, wherein petitioner, before taking to this impugned order, I'd like to take your lordship kind attention to plain to our grievance, my lord, at page 23, para 8.
You are the
and the
plaintiff.
plaintiff.
Appellant is the plaintiff.
Yes, my lord.
Okay, then
And my lord, page 23, para 8 of,
Page
of my
20.
plain,
page 20, paragraph 8,
page 23.
page 23.
Yes, my lord. Para 8.
The suit was for
Ejectment and recovery of khas possession, my lord. Lordship, all these things we have explained only in paragraph 8, my lord.
no,
of
no,
the
that's
plaint.
the ejectment and recovery.
Yes. In the suit, my lord, is the undivided property, my lord. Our mother is the Aparna Hazarika, my lord. He left 9 legal heirs. Out of 9, 2 died, my lord, and left 7, my lord. 7 legal heirs.
Yes.
Yes. Then, my lord, she left the property, my lord, is areas 2 katha, 1.33 lakhs, my lord. 2 katha, 1.33 lakhs, my lord. So if it is divided in 7 equal share among the all legal heirs, and all the heirs entitled 5.9 lakhs, my lord. But in this case, what happened, my lord? The defendant number, principal defendant number 1, my lord, undivided property, my lord, she most clandestinely, my lord, she applied, exceeded the amount all she is entitled, my lord. She applied for the circle officer and obtained a separate duck patta number in this case, and 9.7 lakhs, where she entitled 5.9, and the lakh she
Let us
applied.
see the impugned order.
Yes, my lord. Before taking to impugned order, my lord,
Let's see the impugned order.
already there is a stay order, my lord, was earlier, my lord. Page 70, annex 7.
This is at the stage of admission. So let us see the impugned order.
Yes, my lord.
First step, we will admit it.
Yes, my lord.
Let us have a look at the impugned order.
70, annex 7.
7-0.
Yes, my lord.
Yes, please read.
The instant Miss Sencho case is registered on the strength of petition number Sencho filed by the petitioner plaintiff under all the 13 at rule 1 of CPC. Both parties will be heard, fixing 10-8-23 for objection, my lord. This is, so we agree on this case because why, my lord? Already this learned trial court, my lord, is page 58 and extra 5, there is status quo order passed. We have filed separate IA in this case 901-2022, wherein considering our pleadings, this that on trial court has granted status quo and asked the opposite party number 1 to maintain a status quo of the suit length till next date, my lord. That is at page 58, my lord. Order dated 1/10/2022, my lord.
Just a minute. Who are the parties in the suit?
My lord.
Who are the parties in the suit?
My lord, legal heirs, all the legal heirs. And principal.
No, in page 70, we find different names, right? Who is Harishwar Kumar and Gangadhar Kumar?
It is one. My lord, it is typographical, yes, but typographical error, my
What
lord.
about the title suit? Is it the same?
Is a 6, yes, my lord. 6/1/10/2022 and petition 676
I think
2027.
this is a mistake probably. Are they by any way connected or any connected suit?
My lord, correct party's name at page 60.
Now, we have seen from your area of parties. Are these persons somehow connected to the suit?
No, my lord.
Maybe a mistake.
Yes, absolutely.
You have not noticed this.
Yes. That's
No,
My
how
lord,
do you agree? with
our
this?
application is at page 60, my lord.
No, Mr. Videka, how do you agree? with
Yes, we are agreed with this. Already this honorable court is directed, this landed trial court to maintain a status quo. After obtaining that order, they filed WS, my lord. They are very much aware, my lord. Despite this, my lord, status quo order, they are continuing the construction, my lord. I have enclosed all the construction, my lord, in my IA application here, my lord. And we have brought this knowledge by separate application under order 30 and rule 2A, my lord. That we
Now,
have to-
have you filed for violation of this status?
Yes, my lord. That is
What was-
pending, my lord. That is
then?
pending. That is pending. After no action initiated by the landed court so far as that
Now, what orders kind of orders
At this stage-
are you expecting?
at this stage we are before this honorable court, my lord. Since, my lord, our 2 application is pending, my lord. Last order also the court is directed for next date. By that time, all construction will be completed and all the circumstances will change,
If you are contending
my lord.
that there is an order of status quo
My lord.
which is being violated,
Yes, my lord.
there is no point the status quo being passed by this court. If violation is on, violation will still continue. 10-8 has been fixed. Why did you flesh out the matter on 10-8?
My lord, Since learned trial court, my lord, if it is allowed to continue the construction, my lord, whole matter, the grievance of the petitioner will become infractious, my lord.
Who has allowed continuation of the construction?
And,
Nobody has,
principal,
no, has the trial court asked them to go ahead with the construction?
no.
Trial court has given an order of status quo.
Absolutely.
It is on their own risk and peril. They have gone ahead with the construction. You have filed an application for violation.
My lord,
Pursue that application. If you are aggrieved by some action orders, you come before this court.
my lord, we have pursued, my lord.
If you are aggrieved by inaction, you come before this court.
If your lordship kindly have a look, my I application, my lord, I have enclosed.
No, at least yes, will it benefit you if we appeal this appeal?
My respectful
And,
submission before this court,
if
my
you
lord.
are- if
I
you-
understand, my lord. I understand what, lordship,
Since you have already submitted
my lord.
that an order of status quo by a court has been violated, we are not going to pass any or reiterate a status quo which is already in operation.
My lord, under similar situations,
We can request the trial court to
My
take
lord.
up the matter on 10/8/2023 on the date fixed without giving any adjournment and dispose of the.
yes. Sorry.
Order
Yes,
to-
my lord.
I think that-
Yes, my lord, I agree.
And that order, I don't
Yes,
think
your
the
lordship.
other side will be prejudiced.
Lordship, absolutely right.
Since 10/8 has already been.
Yes,
fixed,
yes, absolutely. We are agreeing.
Third, PK Decca, Credit Council for the appellant who is the plaintiff in title suit number 610/2022 and the connected Miss J case number 676/2023 pending in the learned court of the civil judge number 2, Kamru M. Wahan. The suit is for ejectment and recovery of past possession.
My lord.
Full stop. Sarah, considering the limited,
My thank you.
considering the nature of the relief paid for and also the facts and circumstances of the case, this court is not required to go into the detailed facts of the case. Full stop, Sarah. The Sri Decca General Council has submitted that in the connected miss case, there is an order dated 110, is it 110?
Yes, my lord.
110/2022, whereby the parties were directed to maintain status quo. Full stop. It is the categorical case of the appellant plaintiff that in spite of the state order of status quo, the respondent defendants in violation of the same are going ahead with the construction.
My lord, principal defendant number one.
The principal respondent
Number one.
defendant number 1. No, the respondent oblique principal defendant number 1 is going ahead with the construction for which a separate petition for violation of the same has been filed and is also pending. Full stop. Sarah. The Learned Council, Sri Decca, by drawing the attention of this court to the order dated 4/7/2023, has submitted that the hearing of the aforesaid miss case has been fixed on 10/8/2023. And if in the meantime, the constructions are carried out, the entire purpose of filing the suit in which an order of status quo has been passed would become infractuous.
My lord.
Full stop. Sarah. This court, after consideration of the submission, is of the opinion that since the petitioners, the appellants have taken steps against the allegation of violation of the status quo order by filing separate petition, no grievance as such appears to have been made out by passing of the impugned order dated 4/7/2023 full stop. At the same time, the apprehension expressed by the appellant cannot be totally overlooked. Full stop. Para. Therefore, this court is of the view that interest of justice could be met, that met if a request is made. An interest of justice could be met if the petition is heard on the next date fixed, that is 10/8/2023 by the learned court. Full stop. Para. This court, no, para, no. This court is also of the opinion that by making a request in that line, issuance of notice before disposal of the appeal may not be required. In view of the above, the instant appeal is disposed of by requesting the learned civil judge number 2, Kamrup M. Guwahati, to take up the miscase number 2 into connected miscase number 676 2023 connected with TS 610/2022 for disposal on the date fixed 10/8/2023 without granting any adjournment. The appellants are also at liberty to pursue their application filed for alleged violation of the order of status quo dated 1/10/2020. Appeal according to tenth court.
I'm deeply obliged, my lord.
In the IA, right? In view of the final orders passed today in FA 434 of 2020, no order is requested to be passed in this IA, and according to the same is
Obliged.
Yes.
Lordship, here I appear for respondent number 1 and 2, Lordship. The matter has already been admitted on 7/4/2016, Lordship. It has to come for hearing, Lordship.
Where is Mr. Mubarak or Rashid?
A little while I saw his junior, but now she is not here.
Healthcare has come.
Lordship,
None appears for the appellant on call. Whereas MSF Ahmed, Learned Counsel, is present for the respondent numbers 1 and 2, who submit that the appeal has been admitted and the healthcare have also been received. The appeal being of the year 2000. Why has it come for hearing? Under 41 Rule 11? Not been admitted.
no, Lordship. It ought to have been come for hearing, Lordship.
You're correct. Has been admitted for the wide order dated 7/4/2016.
16.
Correct. And the same has been full stop. It appears that the appeal has been wrongly listed today under order 41 Rule 11. Full stop. Office is accordingly directed to release this case for hearing in its start.
Lordship, deeply obliged. Lordship, matter may be passed over for time being.
What is the matter?
My lord, I as a plaintiff, my lord, the respondent as plaintiff filed a suit for declaration of right title interest.
Your file.
I have filed and recovery of possession, my lord. My suit was initially dismissed by the learned trial court, my lord. On appeal, my lord, my appeal was allowed.
Reversal.
Reversal.
Thereafter,
My lord, they have filed the second appeal, my lord.
what is your source of right?
Source of right, my lord, inheritance.
Inheritance.
Inheritance. In fact, my lord, in the written statement, as
And your predecessor has purchased it or what?
They also inherited, my lord. Both are brothers, my lord. They possess 22 bighas of land,
Oh, both are brothers.
brothers, my lord. But their claim is that, my lord, they have filed counterclaim also. They have admitted my title and they have said that, my lord, in the year 1972 and 2002, we have sold the land to unregistered sale deed, my lord. That's why, my lord, their counterclaim was dismissed, my lord, and my appeal was allowed.
Your title as such has not been
Not been
disputed.
denied, not
And
disputed.
they say that they derived the title from a sale deed
Sale deed,
executed by you, which however is not registered.
registered, my lord.
And a weak case. Absolutely weak.
Lordship, senior counsel will appear. His other room. Kindly pass over for timing.
But pass it over, don't worry. We'll not pass an adverse order in absence of your senior. Let him come. He's coming otherwise. For a while. Same matter. There are two stay matters. If the bar insists, we can take up the stay matters before the order. So that's what you are referring.
Yes, Lord.
Item
61. No?
61. 60, there's 60, I think. If the learned council are there, we can take up 60 and 61. 60.
60, I am for the 60.
Here for the, yes.
I am for the petitioner. Matter may be possible, my senior is in another court.
Okay. We'll take up in turn there. Mr. Dutta, you are ready?
Yes, Lord.
It's a 61 will 60 will have in turn, okay? It will come serially. Yes.
My lord, in item number 61, I have received the wakalatnama just today, my lord, along with the notice. So I pray for some time to produce the records, etc. I'm just entering appearance for all the respondents.
The only difficulty is your lordship is the landlord tenant case. And it's a case of 2016, still going on, your lordship.
You are the landlord.
I'm the landlord. And in the landlord tenant case, your lordship, that the counter claim has been allowed.
We cannot say that they are not.
So therefore, your lordship, what my
entitled to a
prayer is that.
We'll fix a date.
Yes,
Madam,
on the 8th of August, your lordship kindly ignore it.
My lord, the 8th August, actually, there is one fixed matter, my lord. If it could be on 9th.
Yes,
We'll have it a date convenient.
on 9th.
Convenient to
I
heard repeat of the senior counsel for the petitioners. This petition has been admitted or not?
It is on motion because we requested the court, your lordship, that, yes,
Only
that
notice
matter
was issued.
being disposed of on the motions.
It will come for admission on the next date.
No,
Online.
Lordship.
Admission, it will be better.
Lordship.
Third, repeat of the senior counsel for the petitioners who submit that notice was issued and the matter pertains to a dispute between landlord and tenant, and which is pending, and the suit was instituted in the year 2016.
2016.
Madam, your name?
P. Agarwal, my lord.
MSP Agarwal has, learned counsel has submitted that she has been instructed to appear on behalf of the respondent, and the formal wakalatnama
Is in the process of being filed,
it would be filed during the course of the day.
my lord.
She accordingly prays for some accommodation. Course of Para, considering the above, matter is adjourned to be listed on 9th of August.
Yes, Lord.
And
My lord. Oblige, my lord.
the matter would come up under the admission column.
Intending to continue.
Interim is still limited by date or what?
Yes, till date. Interim, in fact, goes against me, your lordship, but however, it cannot be proceeded, your lordship, without this.
This suit has not proceeded.
No.
Why?
Because the issue before this court, unless this is disposed of, your lordship, Should cannot, because the counterclaim has been allowed by this tribe.
Second complaint.
Which the second counterclaim, first they come, so therefore you.
The interim order passed earlier. Stands extended till the next date of listing.
Next date.
Nine.
Well, then this appeal, file in order of reversal. Nana, plaintiff file a suit for declaration of right title interest. We also file a counterclaim. Both the suit and counterclaim.
You are not disputing the title of the plaintiff.
No, it is correct, but
You are saying that if we heard Mr. Iqbal correctly, then you are saying that your source is a sale deed
Yes.
from the plaintiff,
yes,
which however is not registered,
unregistered.
unregistered, which
In
not registered.
72 years.
Then if it is not registered, will it have any legal sanctity?
No, it is correct. That is why my counterclaim is in dismissed. But their suit has been dismissed because your lordship kindly say the planet could be held in lordship kindly page 78. How can my lord, they did not disclose the land, what is the land, what percentage of the land is remain, my lord. Page 87. It is the judgment passed by the Munship. Paragraph 60.
The appellants are the
My-
defendants, correct?
Yes.
You have also filed a counterclaim.
Yes. That is why my counterclaim has been dismissed.
Then,
But they also failed to establish their case also, my lord. In page 87, paragraph 60 of lordship kindly say.
suit is for
So for declaration of right title interest, recovery positions,
recovery is also there.
recovery positions. Now they say that we are in permissive position.
The-
They fail to establish it.
Yes, page 87.
Page 87.
Yes.
Just paragraph 60, my lord.
60.
60. But the PW1 made it, my lord.
Yes, yes.
But the PW in his cross examination has stated that he has not submitted the patta of the land measuring 1 bigger so. The PW2 in his cross examination had stated that his father sold the land to Mokbul, Siraj, Ainal, Shahjahan, and one other persons, but he does not know how much land was sold to them. The father stated that the entire land is recorded in the name of his father and uncle Hussein Ali. The PW3, who is not a party to the suit, in his cross examination has stated that the land documents of the plaintiffs remain with the plaintiff. He does not know in which districts the land of his father-in-law and the brother of his father-in-law exists. PW3 stated that he does not know which part of land falls in the shares of his father-in-law, i.e. Hussein Ali. He knows to whom Afal Sheikh sold land out of his share portions. Afal sold 1 bigger Swensu, 1 bigger of land to Andaz Ali, and 1 bigger of land to Ainal. The father stated that after partition of the total land between his father-in-law and the brother-in-law, their names were recorded in the record of rights. No one from PW's court clearly and specifically stated to the area of land to whom the plaintiffs or their fathers whole land out of their alleged portions of Swensu Biga. No document is adduced by the plaintiffs showing the land measuring Swensu, the share of their predecessor Afal Sheikh. In the plaintiff stated that Afal Sheikh sold 2 bighas of land from the same dag to Khalek Sheikh, and the remaining land 2 bighas Swensu in dag number Swensu, neither in evidence of the PWs nor in the documents which are exhibited by the plaintiff name Khalek Sheikh reflects. The defendants also included 3 katas Swensu letters of land alleging to have purchased from Hussein Ali in their counterclaim, claiming right title interest thereon,
has shown that 3 kata 15 acres of land as part of Schedule A land of the plaintiff. In such circumstances, due to failure on the part of the plaintiff to specifically mention and establish before the court as to what is the next exact area of land that remains in the part of the plaintiffs, it cannot be plainly held that the plaintiffs have right title interest over the Schedule A land, and as a result, this issue is decided negative. So it is clearly held. And now the appellate court, my lord, without appellate court is the court of facts, my lord. He should have discussed the all the issue wise, my lord, and taking also elaborately discuss the evidences. Nothing, my lord. No, there is no discussion. Now, the appellate court held that since the defendant admitted that they are the owner, so he has established the case. So, learned court will has committed the wrong. This is the play, my lord. Now, the learned appellate case should have discussed all the issues, my lord, on fair manner and reflecting the evidence, evidences. He discussed the evidence, nothing. He has not discussed the evidence, my lord. So, my lord, since 1972, we are in positions. And the unregistered deed executed by the father, it is also binding to them, my lord. Maybe I have not get the ownership, but it is that unregistered deed are binding to them, my lord. So, my lord, I file counterclaim. That is why my counterclaim is dismissed. I am not a file appeal, but it is not a ground that they should get dignity, my lord. Non-filing of appeal by no possible on my part, it is not a ground that he automatically got the degree. So, my lord,
What are the first appellate court against the dismissal of his suit? That has amounted to a decree, which is the subject matter of challenge here. We may not be inclined to whatever you submitted for your counterclaim. We may accept that.
yes.
Counterclaim dismissed, you have not filed an appeal. By that, it will no automatic benefit will go to
Yes.
him. But there is an independent suit by him,
That
which is
was
ultimately declared
because-
by the first appellate court.
Yes. Because that is dismissed, because I,
No. The dismissal of the suit by the trial court was continued in the first appellate court.
Yes.
It's a continuation of the proceeding.
Yes.
Now it has culminated into a decree which is the subject matter of challenge here.
Yes.
Now there is a decree in his favor.
my lord, there is a
It
degree,
may not be too much,
But-
we can separate your, segregate your
but
counterclaim.
the plaintiff should have established his case. He should have specifically mentioned the lands, what is the land, what part of the
There is
land.
no substantive
remain-
question of law, wherever it is.
The substantive question of law,
In your questions of law frame,
but substantive question of law is that, my lord, in my understanding,
we have seen.
that the learned appellate court will has not discussed all the issues in accordance to order put on rule 31, my lord.
What is the violation of order 41 rule 30?
Because first appellate court is a court of fact. my lord.
Violation.
He must have,
Order 41 rule 31.
Yes.
The contents of the judgment.
Yes.
What is the violation?
violation is there. He is not discussing the evidence, my lord. He should have discussed the evidences, my lord, and issue wise. He has not discussed all the issues, my
Let
lord.
us see the
Yes.
appellate court that
Yes, my lord. Page 7.
is 7.
Yes. It is started from, my lord, illustration can see page 21 from onward, my lord.
Yeah.
Yes.
He has formulated 3 points of determination after verbatim expecting the issues in paragraph 27. See, all the issues, he have taken note of 9 issues, then he has formulated 3 points for determination.
Yes.
He has discussed all the points We are not looking for
No.
discussion in 100 pages. I
No.
think
But,
concise discussion is better.
but fact is,
Precise and concise discussion.
but fact is this, my lord, he should have discussed the evidences, my lord. DW's evidence not at all considered, my lord. Not, nowhere it is reflected, my lord, in the judgment. And even the PW's evidences.
It's considered. Come to page 25, 26. 26 years in fact expected.
Yes, 25, my lord.
Yes, 25, 26.
Like, it is there, my lord, but where is the evidence part, my lord? Well, how can he come to the conclusions, my lord? Whether he re-evaluate the evidence, my lord, evidence
The
of records,
appellate
my
court
lord?
exercises powers as an appellate court. You may be corrected as a court
No.
of fact.
Uh,
He'll go, but
Yes.
unless there is something glaringly appreciating the same, there has been some glaring error. Otherwise, points have been properly been
But,
formulated, discussed, and he's come to a conclusion.
but the learned Munshif has very nicely, he discussed the issues, all the issues and discussed evidences, my lord. But he should have commented those part, my lord. Nothing has been done, my lord. Nothing has been done. So the learned appellate tribunal has passed the judgments without considering the case of the appellants, my lord. And
Not good enough for an arrest.
the findings is appellate will suffer purposely on account of misinterpretation of evidence on records, my lord.
You have not been able to demonstrate what is the misappropriation, wrong application.
Because being a court of fact, he should have discussed
Where's
the evidence on records, my lord.
Show us.
That's the Small loss of judgment. There is nowhere mention about the evidences part, my lord. Who says what, did will show what is the did will evidence, my lord? Nothing, nowhere mentioned.
Why?
Evidence of the did
How
will
is
not
it?
at all consider.
For example, let us read page 21, paragraph 32.
Yes.
There is a direct reference to the evidence.
It only PW some, my lord.
Yes, please
Yes,
read.
plaintiff,
Number 3.
32. Plaintiff is number 3, Ismail and plaintiff number 4, Johar, examine themselves, Peter 1 to 2, respectively. Both of them has filed their examination sheet, but none of them exhibited any documents in support of their claim.
Yes,
However.
however,
In their course examination, both PW 1 and 2 replied that they have submitted the pata of a lot of land measuring 21 bigas, 22, exhibit 5. They also replied that they have not submitted other pata land measuring 22. No, this is the case, my lord.
so
That
this
is the landed.
No, you just now you are making a submission that there is no discussion on the evidence. There is a direct discussion. Not only is discussed, he has also noted that in the chief, they has not said something, but in the cross-examination, everything has been brought on record.
But to establish that evidence, my lord, to substantiate
come
the
to
evidence of
paragraph-
PW 1 and 2,
Come to paragraph 3, paragraph 33, the next
Yes.
paragraph.
the argument of the law about evidence is that some of the defendant in the written statement have admitted the title of the plaintiff's position and as such, the plaintiff is not required to prove his title. He further submitted that the defendant admitted that they have purchased land from the petitioner of the plaintiff. He also submitted that the fact admitted need no proof. Learned counsel for the appellant's plaintiff submitted further that all the land documents are exhibited in this case by PW 3 Abdul Qasim. He is not the plaintiff, my lord. He is not the plaintiff.
Please read 35.
Yes. In the written statement as well as the counterclaim, the defendant submitted that they have purchased land from Hussain Ali and Apal Spencer by executing unregistered sale deed. In his examination in chief, the defendant number 3 and DW 1 deposed
Suppose
that
that during
Hussain Ali and
his
Apal
deposition-
said stole land measuring his father Alabuddin by unregistered sale deed.
in his
in his-
cross-examination.
In his correspondence, he has specifically admitted that Afaz Uddin and Hussain Ali are brothers and they had 22 bigas of land, but personally he does not know the exact number. He also admitted that his father purchased land from Hussain Ali, Afaz in the year of 1972 by of unregistered sale deed.
What else is required? How much discussion? How much discussion?
But the plaintiff should have
If we find that the relevant things have been discussed,
But the plaintiffs would have
We
proved,
are not looking for some very elaborate kind of a. And this is the appellate court.
but the plaintiffs would have proved the lands. And the learned Munsif has rightly passed the order, my lord. Rightly dismissed the suit.
And we don't find any substantial questions of law being raised by you. We have examined the questions which you have presented before this court in your appeal at page 5, 4 and 5.
My lord.
And what Mr. Iqbal has initially pointed out, that your source being the registered, being a deed which is unregistered, your entire case becomes very, very weak.
But those deeds are binding to the heirs, my lord. Those deeds are binding, my lord. It should be examined, my lord. Because those deeds,
That
70,
that was your sole plea, that there is this deed of sale. which
they also
our-
not denied it, my lord.
No, they are not claiming, they are claiming by means of inheritance. Yes, fairly stated, both of you are brothers.
My lord.
And out of inheritance, his share, you claim to have purchased by a deed, which however is not registered.
But my lord, whether the exhibit A,
If you are not disputing this fact, then we are in a difficult position. We will not be able to help.
my lord, but
Yes,
but the only fact is, my lord, whether exhibit A, B, C, D were binding on them, my lord, legal heirs, my lord. Because their fathers sell it, my lord. On whether those deeds are binding on them, my lord.
Mr. Ahmed, we'll go to that question only when you question their, challenge their title. Their title you have not challenged. Initially, you are both at the same, at par. You have got the land by inheritance. And his part, which is the subject matter of suit, you claim to have purchased by a sale deed from him, which is not registered.
And another play has been taken here, I found.
And your counterclaim having been
Yes.
dismissed, and there is no appeal, further appeal
Yes.
to that.
It is there, my lord.
You have closed your doors.
But it is another aspect, my lord, that since 1972, they are in positions openly, frequently, my lord. So in this way,
You were in
become
position.
adverse.
You,
We are in position.
have you taken the point of adverse position? You
Because
take
I'll-
point of adverse position as a shield.
Because
You
I'll-
take it. That is not an issue.
That is not.
that was discussed, that was discussed by the court.
The issue, let us see the issue again. I don't think that's an issue.
It is
That
not
issue
framed,
is not framed. in fact.
That's
but-
not an issue.
but it has been discussed. It is discussed in the.
No, see, adverse position, just like that, you cannot say.
Hmm.
You are extinguishing the right of a lawful owner.
Yes.
No doubt, the law of adverse position gives you the right, but you have to make out a very strong case.
My lord.
You just cannot dispose of somebody on the plea of adverse
But
position.
but question is this, my lord, only that
We
earlier,
are not going to that issue.
earlier days, my lord, those people are selling the land in this way. There is a trust on this. Nowadays, my lord, by taking that advantage,
You may be
they're
right if there was no litigation. Now, once it comes to the court of law, we have to go by the law.
my lord.
We cannot go by what was going on in between the parties.
So let this matter examine record will fall. Let us we examine the evidence on records, my lord. Since it is the last scope, my lord, let the record come and evidence on records we.
You have not framed substantial questions of law. We are not inclined.
The lordship is the.
Come to your 4 questions, 5 questions framed. The first 4 questions are nothing, totally vague. At page 4.
It is just I refer. The lordship is to be framed as such a reasonable law.
You have to at least give us a draft question, or at least give us the basic background that this is the question which you are trying to raise before this court. Definitely we'll frame it, but we don't find any background. Yes, what do you say?
My lord, as discussed, my lord has come to the paragraphs number 31 to 37, my lord.
Yes.
It has been elaborately discussed, my lord, by framing points of determination, my lord. Reasons have been given elaborately, my lord. as such, my lord, order 41, rule 31 doesn't come in our case,
Ah.
my lord. And my lord, the vital point that was not considered by the learned.
No, I
trial court,
think order 41,
Rule 31,
order 41, 31 has just been taken.
my
for
lord.
the sake. I don't find there is any violation of those requirement. Contents of the judgment, procedure prescribed. I think it's followed. What else does the appellate court do? It has taken note of the issues, framed, formulated its own questions of determination, answered those, discussed the evidence, whichever was discussed by the trial court.
My lord.
Procedural part, I don't think you have any case of
But
order
since,
41, rule 31.
just so I pointed out the page 87. So landed court below has very rightly held. Very rightly held.
We give you a further chance. Come day after tomorrow with some substantive question.
It may-
Otherwise,
It may be, my lord, next Monday, next Tuesday, my lord,
not next Tuesday. Day after tomorrow or Friday.
Friday. my
Friday.
Friday.
Third. We don't want to dismiss on the first day. We'll have 2 days of hearing. Friday, we're going to discuss.
Hey, my lord.
Heard the Ahmed Leonard Council for the, you're on caveat.
I am paid it only on behalf of respondent number 2.
Heard the Iqbal Leonard Council, who has lost this caveat in respect of a judgment and decree dated 13/2/2023, passed by the learned civil judge Pokrajhar, entitled Appeal number 9 of 2022, put up by the state judgment, the decree, the judgment and decree passed by the trial court has been reversed. Correct?
My lord.
Put up. The caveat would be heard in the event this court proposes to pass and any interim order. Caveat stands discharged. Since being you read, heard through J. Ahmed Leonard Council for the appellant, whereas 3A Iqbal has entered appearance by means of filing a caveat for the phone number 2. For para. After hearing at some length, at some length and on perusal of the substantial questions of law frame are presented on behalf of the appellant, this court is of the opinion that state question may not constitute any substantial question as required under section 100 of the CPC. However, in the interest of justice, let another opportunity be granted and the matter be listed for admission on Friday next. Give it.
Deeply obliged.
May I please, your lordship?
Yes, yes.
Lordship, in this case, lordship, matter has become infectious, lordship. I am appearing on behalf of Lawrence Senior Consumer GP Government. He has instructed me that matter has been infectious.
My lord, it's related to service matter, seniority dispute between the teachers, my lord. I think
He has already retired, lordship.
they are all retired, my lord. The question of law is involved, my lord. There is specific bar to the my lord, civil court in matters of service, my lord, service condition. That was the points we have raised here, my lord. Afterwards, my lord, the case is infectious, my lord, but very important legal questions is involved in this case.
We'll leave those questions open to be decided and appropriate.
My lord,
This item number
item 15.
third PA or the direct clause for the petition. Whereas
Appellant.
for the appellant, where your T. Sharma, what's the name?
D. Kolita, lord.
D. Kolita.
D. Kolita.
Whereas D. Kolita has appeared for the sole response.
Full response.
Para. D. Kolita, the learned counsel.
Respondent number given.
There's only one respondent.
Sole respondent নহয়, পাঁচজন আছে respondent, আপনি কি number itu go. He is for private respondent.
Private respondent.
Five. Not sole respondent. Sole respondent meaning below.
So now who is for the principal respondent plaintiff?
My lord,
You are the plaintiff, I think.
yes.
I am for the respondent, Lordship. They are plaintiff.
No.
I am
It is
plaintiff.
absolutely
I-
misleading submission.
Don't say misleading, he is not aware.
No.
Why would he mislead?
I'm appearing on behalf of Lordship. That's why I have no.
He is the mistaken submission.
Mistaken submission, my lord. Yes, ma'am.
The brief is not available.
For the principal respondent, who was the plaintiff? For the three collision, the learned counsel has submitted that the respondent has in the meantime retired from service on attaining the age of subordination. Though this fact has not been disputed by Priest Victor and counsel appearing for the appellant, he submits that there is an important question of law involved. The counsel, however, at the same breath, has fairly considered that in view of the peculiar fact that the plaintiff respondent has retired, this appeal may be closed with the question of law, and the question of law may be decided in an appropriate para. In view of the aforesaid facts and circumstances, the instead appeal then closed. Of the question of law involved remains open to be decided in an appropriate.
Deep lovely.
Please, Your Lordship, this matter is ready as regards to service and LCR has been received. The matter may be posted for hearing, Lordship.
All persons,
Lordship, sole respondent.
all the respondents. Yeah,
Sole
what is-
respondent, Lordship.
Sole
respondent.
it is submitted that service is complete and the sole respondent has in fact appeared, the LCR has also been received, list for hearing.
Obliged.
I'm allowed to see the LCR now.
Yes, please,
Obliged, Lordship.
you can make note.
Please, your lordship, engage advocate lordship suddenly out of station lordship. Therefore, lordship, 1 week time may be gentle.
Oh, you had made a mention in the morning.
Yes, sir, lordship.
Where is STC? Mr. Roy?
Yes.
STC? STC,
I know, but I, because this is 2011 matter, my lord,
are you appearing or not?
I'll be appearing. My lord.
So he is taking some time. You have the record,
I don't have the records, I will check up. my
you
lord.
reconstruct your file,
I'll reconstruct.
take
my
help of the Senate counsel or apply certificate copy for you. But this is an 11 matter.
Yes,
Where is he gone?
Shiksha lordship.
It is submitted as the PJ for Senate counsel appearing for the appellant had to leave the station due to some urgent purpose.
Number to the-
Also heard P.J. Roy,
9864. Under 7.
counsel, senior counsel appearing for the ASC. Put some para.
75.
So this matter is of the year 2011, as an exceptional circumstance, a short adjournment is granted direct listing of this matter on?
After 4 weeks, fine.
No, 4 weeks, 11 matter.
August first week.
Huh?
3 to 10.
We'll have it on, days, wait, 4th. We'll have
Yeah,
it on, we'll have it on 4th of August,
First, 4th argument, remand option.
2nd of August,
7th,
7th of August,
7th.
7th for disposal.
Yes.
Welcome.
May I please, my lord? My lord, as per office note dated 23/6/2023, my lord, the respondent number that is wrongly written it to me, it ought to have been 5E, my lord, has left without any instruction, my lord. 23/6/2023, my lord.
Yes.
It ought to have been 5E, my lord, wrongly written. She has left without any instruction, my lord.
So what do you do now?
My lord, I have to take trace steps on her address after searching her whether she is now, my lord. Others, my lord, service is complete, my lord.
Who is 5E?
5 is Mrs. Elena Begum. She is
No,
the
no, we are not interested in-
legal heir of my lord, respondent number 2, Sirajuddin Ahmed, my lord.
Oh, connected.
Connected, my lord.
Take or 2 pen. Flag. You like take instructions or what?
Yes, my lord, I have to take.
Yes.
I'm
the
appearing for
Corridor
respondent number 4A to 4E, Lord.
4A
4A to 4E. I'm appearing for 4A to
and
4E.
5. Who is appearing for 5? Madam for
I'm for 1, 2, and 3, madam, comment.
government. Who are the other respondents?
But other respondents, my lord, nobody has appeared, my lord. All the service on my lord 5A to 5D complete, my lord.
5B is it required to be intact, kept intact?
My lord, since there is a mutation order is in favor of all the persons, my lord, and that is under challenge, my lord.
So that is an affected party.
Yes, my lord.
But this matter is of 11.
Yes, my lord. And the CRP is of 2008, my lord. One after another, my lord, respondent died, my lord, in the service.
A Gupta has done a counsel for the applicant petitioner has submitted that so far as service upon respond number 5 within bracket E is concerned, comma, the service has returned back with the endorsement within inverted comma accuracy left without instruction. Footnote. He further submits that while reflecting the same by the office note, by the office in its note dated 23/6/2023, comma, the number, however, has been wrongly written as respondent number 2 within bracket D, which should have been 5E. Full stop. This court has also taken a look at the returned envelope which is kept in the part 2 file and marked as X. Sri Gupta, the learned counsel, accordingly placed for some time to obtain instruction. Also heard MS Das learned CCC,
Additional senior government.
additional
Senior
additional
government advocate.
senior government,
Additional senior government
additional senior government,
advocate Assam.
additional senior government advocate of and Sri D. Collision for as possible
4A to 4E, Lord.
4 compare. So this is an old matter, comma, under the opposite facts and circumstances, that comma, how many, how 2 weeks? 2 weeks. 2 weeks time is granted to the learned counsel to obtain instruction.
Obliged.
You try to get the present address.
Yes, ma'am.
Instructions regarding the present address of the respondent 5. Item. Yes, 20. B. Goswami, A. Hassan. Fourteen matter. None appears for the parties on call. This CRP is pending since the year 2014. Put up as a further chance, comma, matter is adjourned to be listed on Friday next. Put up. It is however made clear that in case of further non-appearance of this court may proceed to pass appropriate orders. Which case
The defendant number, respondent number 1 expired. We have filed petitions. But the original petitions, we are not belated the legal heirs as party. It is mentioned, although mentioned in the body. Thereafter, we filed another petitions, belating their name. The notice was issued to them. But as per office note, I found that they are not found. Office note dated 26/6/2023.
1E you have served personally.
Yes.
1E.
Yes.
A, B, C, D, and F not found.
Yes.
So what is your submission now?
Although AC Sharma appeared earlier in those cases or both the defendants.
Names shown or not?
Names shown.
Yes, who is appearing now? Mr. Sharma, B. Halder,
Yes.
M.K. Bora. Will they appear for the other respondent?
Yes, in original, respondent to defendant to appear. Two others.
Let us try it on Wednesday then. If they come, then perhaps if they accept.
Yes, I will come next week. It may fix.
Okay, next month.
Next
Next month. Not
Next
next month. It's a matter of 2010.
Yes,
Next Friday or Monday, whenever you say.
next Monday. I also inform my clients, also issue
I'll treat-
letter. But
Yeah, I made letter counsel for the petitioner, who by referring to the office note dated 26/6/2023 has submitted that except for respondent number 1 within bracket D, the other respondents, namely 1A, 1B, and again up to 1F, have not been able to be served with the endorsement within inverted comma, not known, comma, then return to center. So far as Respondent number 1F is concerned, comma. The endorsement is addressed wrong, return to sender. The cause list, however, reflects the name of some counsel. Since who are not present today, and the matter is called for compara. In the interest of justice, list for orders on Monday next.
Yeah, please, madam. Madam, as per office note dated 27/23, madam. Neither AD card nor answer notice in respect of respondent number
2C.
2C, madam.
Yes, you're appearing. Mr. Uptan.
I am appearing, my lord, respondent number 3,
3, 5, and 6.
3, 5, and 6.
Madam, you have 4? 4. What about 2?
Madam,
When did you take step?
my lord, I have taken a steps on 19/5/23, my lord, it was dispatched. Office notice there, my lord, 19/5/23.
And 2C is the only respondent left out.
Yes, my lord, all other service complete.
Okay, we'll have it deemed service. Okay.
Yes, please.
Sri A.K. Gupta learned counsel for the petitioner submit
2C.
that notices were issued to the remaining respondent number 2C by registered post which as per office note dated 19/5/2023 was dispatched on the same date. Full stop. Para. He has also referred to the subsequent office note dated 27/2023 as per which neither AD card nor answer of notice has returned back. Full stop. Para. The DCC MS. Where is your current number, madam? Have you filed your current number? Your name is not free.
In case 661 is.
MSP has appeared for the number 4, whereas the DCC Fukar is present for the response was 3, 5, and 6. Full compare. List.
My lord,
This case,
my lord, this IA is for condonation of delay. My lord, what happened in this case? 3 respondent died. So I have filed 3 applications, my lord.
there are other applications also.
No, this is for delay. One is for setting aside abatement and one is for.
No, it's for the
substitution.
delay, we'll have a team served. That
Yes.
will, list this case before the learned Lawzima court to pass appropriate orders on deemed service upon the respondent number 2C, who is the only respondent remaining to be served. Whereafter the matter is to be listed for orders for consideration of this application, which has been filed for condonation of it.
All right. All right.
So Mahmood,
My lord, we have filed 3 IS, my lord. IN number 1656, that is for condonation of delay 81 days in filing substitution petition. And IN number 1657, that is substitution petition, and IN number 1658, that is for abatement.
setting aside abatement.
Abatement.
Setting aside abatement.
Yes. Because we are not informed at the appropriate time that so and so have died. So respondent number 2 and 3 have died, and they are.
Mr. Hussain, you are appearing for whom?
My lord, I am the originally respondent number 1, 4 to 13, except 2 and 3 matter. And my lord, 2 and 3 already died. My learned senior counsel filed the
Substitution.
three.
Now there is a delay condemnation. Are you objecting to this?
No, I am my lord, earlier I am not appearing on behalf of the 2 and 3 matter.
No, for the other respondents, are you objecting to the delay condemnation? 2 and 3 are yet to be
2 and 3, my lord, substitute legal already filed this petition. Substitute petition, my lord. I am not.
Who passed away? 2 and 3 passed away.
Yes,
Yes.
I am not earlier appear on behalf of 2 and 3, my lord.
Now you are appearing for whom?
Appearing for 1 and 4 to 13.
Understood. Are you contesting this? Are you,
Condemnation of issue আপত্তি আছে নাকি?
Condemnation, I
or have they been served? The persons you are trying to make parties?
No, they are not yet served because we have filed the other day and your lordship may issue notice to respondent, newly added respondent number 2A and 2, 3, 4 and 5.
2 and 3, I am not appear earlier also, my lord. This is the, he filed the petition.
Which I is for condemnation? 1656.
Yes, condemnation, my lord.
This has to go now.
Condemnation is IA number
1656.
1656.
Oh, notice have not been issued.
Yes.
Third three, M.A. Mahmood Learned Counsel for the applicant who by means of this application, who by means of this application filed under section 5 of the Limitation Act 1963 has prayed for continuation of delay of 81 days in filing the substitution petition on the passing away, on the expiry of the respondent numbers 2 and 3. Full stop. Let notice be issued. That step be taken for service of completion upon the respondent.
Upon the legal heirs of respondent number 2 and 3.
Upon the respondent queries that post petition. Step within 2 days. List up to 6 weeks along with service.
First condemnation only.
Yes.
There are 2 others in this substitution and
Now
abatement.
first delay
First,
condemnation.
yes, public. Public.
Itu Maripa 1656. Madam, yes.
I have appeared to respondent number 2, 3, 4, 5, 6, 7, and 8. Except respondent number 1, my lord. As per instruction, my lord, respondent number 1 expired, my lord.
None appears for the appellant on call. However, MSP Goswami and counsel has submitted that he has appeared for the respondent numbers
All the 2, 3, 4, 5, 6,
for all the
7,
respondents.
all except
For
rest-
all the respondents except respondent number 1, who she submits has passed away in the meantime. Since none has appeared for the appellant, in the interest of justice, the appeal is adjourned to be listed after a week. In the meantime, the appellant may take steps for substitution of the respondent number 1.
My lord, in this matter, my lord, between brothers and sisters, I am told there is some talk of compromise going on, my lord.
No, my lord, first thing, somebody raised this money decree. And they have admitted this amount of, my lord, in the details.
No, what about Mr. Chaudhary's submission? That is,
My lord, no.
you have taken instruction.
Yes, a few days, 3 days back, my lord, I had a talk with him, my lord. And all along, my lord,
Appeal has been admitted.
Appeal has been admitted, the first appeal, my lord.
appeal admitted, my lord.
Appeal admitted and my lord, the
I am
decree was
just
stayed.
admitting, my lord, this is a money decree, my lord, this should not be paid, my lord. What all along, my
Then
lord,
we hear this,
my lord,
we hear this, then
that is under aspect problem, my lord, it can be.
we heard it, 19 matter, we fixed it.
Yes.
Only thing, my lord, is till then, my lord, whether the interim, that money decree should be stayed, my lord. That is what I am saying.
My
At
lord,
least,
the-
my lord, they should pay the 50%. They admitted this is the liability, their liability in the detailed statement.
Is there any stay order?
Yes, yes.
Yes,
There
my
is a
lord.
stay order, my lord.
Interim order is there, till filing of the affidavit, my lord. We are asked to file the affidavit. We have filed the affidavit.
My lord, subject to permission from my learned senior, my lord, what I beg to state is, or he will also agree, my lord. If your lordship kindly sees the last part of the order, my lord, the judgment which was passed, my lord. It is at page
Rejects.
25. May I read, my lord? It starts from the word order.
Just your IA is 949, isn't it?
My lord.
Yes,
Where is this?
and we have filed an affidavit. Huh? Not affidavit,
What is the exact date?
My lord, now
This order, 6/12.
it is like that only, my lord. It is stagnant at that only, my lord.
Yeah, after my matter notice.
It was not listed.
No,
It
what
was
is the meaning, trying to portrayed by the paragraph accordingly?
My pardon, my lord.
You have the copy of the order 6/12.
I don't have, my lord. Apun dada. 612 order to copy.
Yes.
My lord, what happened, my lord? Let me,
My lord,
can I explain to your lordship, my lord?
That was my lord.
Dada, mo kono?
We'll just stop that.
Yes, 612 order is there, my lord.
Then accordingly, what's the meaning? Accordingly, as an interim measure.
Yes,
Until the returnable date, the applicant is permitted to secure
50% declare amount.
and interest
By submitting money bond. And in the meanwhile, we are allowed to till then, till hearing.
No, where is the interim order? It is permitted to secure 50% of the declared amount.
Yes.
By submitting money bond.
My lord. That we have done, my lord.
That correct, my lord. Your lord says very correct.
There is no interim order.
No stage there.
But the meaning of that was, my lord,
Meaning,
my lord, that was subject
my
to-
lord.
perhaps
No,
that was
this-
clarified, my lord, that was by a letter order, perhaps that was clarified, my lord. If I remember correctly, my lord, if your lordship kindly turns over.
So this is the last order,
This is a-
6/12/19.
Yes,
Perhaps that was clarified because we had filed, I remember, my lord, we had filed an application. Because this order did not reflect that, my lord, it would be stayed subject to.
6/12 was the last order.
My
Last-
lord.
yes.
Well, yeah, I did not go through a record, my lord. Yeah, I can recollect, my lord. Perhaps we had filed and that was clarified, my lord. Anyway, my lord, what happened, my lord?
Mr. Chaudhary,
My lord.
for a clarification, there has to be an order subsequent to 6.
My lord, perhaps there is an IA, my lord, there.
There is no
I,
IA.
right now, I don't, I'm not.
No,
seeing that order,
my lord, so far, my record is there is no I. Huh?
There isn't any.
No,
949.
this is the only my lord I. And this amount, my lord, they have admitted in the written statement. If you lawsuit see at page 19 of
No,
the,
we are not going to the marriage.
my lord,
But senior counsel is right, money decree, whatever, marriage may be decided at that.
yes.
If it is paid, you need to deposit.
Supreme Court directed 50% to pay and 50% secured by.
In fact, requirement is 100%,
Yes.
but we may at times exercise our discretion. And you don't come under those exceptions
Yes.
where one order may be passed exempting.
No, my lord, what happened in this case, what my lord led this honorable court to pass that order by securing by way of money bond is because, my lord, if your lordship kindly sees the order in the judgment, my lord, has your lordship got it, my lord? First part is that, my lord, it was declared that they will be entitled to some amount of money.
No, we do one thing. If we have to go to the marriage, we have it for hearing. And since this position is going on since 19th,
My lord,
for 1 week, we're not going to change this.
my lord,
Let it remain, but we'll fix the date for here.
my lord.
Money decrease involved. And if in the meantime, what Mr. Chaudhary says has got any bona fide, you can take the instructions. If you can
Because,
settle
yes, my lord.
outside the court, Are you a
Because
family-
actually I
are you a
myself
family
had
member?
drafted a memorandum of
Are you
agreement,
a
my lord.
family member? Or
Yes, my lord.
Connected,
Me, myself, I am not, but
No, no.
brothers and sisters.
that is it,
Yes, my lord.
brothers and sisters.
Brothers and sisters, my lord. Same father.
Or
I myself had drafted, my lord, a memorandum of understanding and had, my lord, sent it across. That is why on that I say that there's some, my lord,
or
going on.
yes, here for the.
I am for the appellant, my lord.
How each of the Senate council was the appellant, whereas the TN Sahel and Senate council is present for the opposite party. Full stop. Sarah, this Senate council for the opposite part has come that while admitting the after admission of the epic an order has been passed IP 7949 of 2009. As a result of which the respondent decree holders are sustaining, are suffering. He accordingly submits that either a directive issued requiring deposit of at least 50% of the amount, or else the matter be taken up for action. Considering the above, of the Sri Chaudhary, the Learned Counsel for the Appellant, however, submit that a bare perusal of the impugned judgment and decree would bring this court to a conclusion that the same is not sustainable at all. He has also submitted that as per his instruction, there is a talk of compromise as the parties involved are different. That be that is this court is of the opinion that this since an interim order, since the order is 6/12/2009 passed in the IA is still operative, instead of modifying the same, interest of justice will be served if the entire appeal is taken up for hearing and disposal by an article. Accordingly, healthcare is there, and this court has also been apprised that healthcare has been received full support in view of the same that the appeal will be listed for hearing on
Second week of August.
The date may fix,
convenient to both the parties.
11th of, 10th of August.
10th of August.
10th.
10th of
I'm determined.
Mrs. Kyle. Madam, you have for the respondent.
Yes.
None appears for the appellant on call, whereas your name
Yes, sir.
MSS submitted entered appearance is present for phone number
It's not 1 to 9.
129.
9.
Full stop. Sarah, office note dated 76/2023 also reflect that respond numbers 1 to 9 have filed Wakalat number and the AD card duly signed has been received from the respond number 10. para, 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 para. It has also been reflected that LCRs have been received. Since service is complete and LCRs have been received, comma, the appeal may be listed for hearing in its turn. Yes.
Mayor, please, my lord.
The order for whom?
My lord, I'm on behalf of Mr. SP Chaudhary. My lord, his name is not reflected, my lord. Though his name appeared in order dated 4/3 of 2020, my lord.
None appears for the appellant on call of this court, Sri Vishwakarma. Current counsel, however, has informed this court that Sri SP, that you are also appearing,
No, my lord.
that Sri SP Chaudhary, current counsel, is appearing for the respondent whose name, however.
My lord, I am for the appellant. I mean, Mr. SP Chaudhary is representing the appellant here. There was a direction to take
Oh, this is a
steps.
new counsel.
Yes.
Oh, oh. KDV is no longer there. This case.
She is also there, my lord, but Mr. SP Chaudhary is there.
No, no, not this one. So, Sri Vishwakarma council has submitted that Sri SP Chaudhary council is also appearing for the appellant and is presently looking after the case, whose name, however, has not been reflected in the cause full compare list on Friday next by reflecting the name of Sri SP Chaudhary, current counsel for the appellant.
Obliged.
Then they will pass orders.
Yes, obliged. May I please, your lordship? Lordship, the service has not been complete yet upon the respondent number 18I and 2A2F because their addresses have been changed. Therefore, we need to correct the memo of appeal. So we need some time. We need at least 2 weeks, lordship, to correct the
No
memo of
steps
appeal.
for correction of memo of appeal in respect of 1/8. This is 14/6, where you are directed to correct the address.
Lordship, yes, but due to lack of instruction on the appeal.
This was of 30/11/2022.
2022, lordship.
We are in where? Almost completion of July. 6 months, if 7 months, you have not been able to take.
Lordship, yes, due to lack of instruction.
That is it, 6 months, you have not been able to take instructions. How can you take now?
The address, the jurisdiction of the district has been changed. Earlier, it was in Hojai district, then it was converted in Nagaon.
You are required to take the collective, correct and proper present
Yes.
address,
Exactly, lordship.
which you have not been able to do for 6 months, 7 months.
Lordship, the appellant has not been instructed yet, lordship, proper address. We have taken several times.
And how do you proceed with this?
Lordship, at least we need 2 weeks time.
This court by order dated 30/11/2022 had directed the appellant to take steps for correction in the memo of appeal in respect of address of respondent numbers 1H, 1I, and pro forma respondent numbers 2A, CO2, 2F. 2B, 2C, 2F, 2CO. Office note dated 22/11. The Learned counsel, your name?
M. Kalita.
Sri M. Kalita, Learned counsel for the appellant submit that some more time may be granted for the same full compare in the interest of justice. The appeal may be listed after 2 weeks to enable the Learned counsel to obtain the correct address of the aforesaid.
Highly open.
May I please, my lord, in this, my lord, IA, my lord, service is complete, my lord. This respondent number 1 died, my lord. So there is delay of 641. May I please,
Is
my
for
lord?
substitution.
Yes, I'm for the respondent, my lord. The legal here we have that we are appearing, my lord. My lord, I'm praying that it may be fixed for next week. If at all, there is a delay of 641 days, my lord. My lord, if in the meanwhile required, we'll file our objection also.
How to AK Gupta learned counsel for the applicant. Priki Vishwakarma, learned counsel. Appearing
For
on
1A
notice,
and B.
on notice, on the appearing on notice on behalf of the parties who are thought to be substituted, prays for some time to file objection to this delay condemnation application. 2 weeks?
Yes.
Please after 2 weeks to enable filing of such objection.
Obliged, my lord.
Lordship, may kindly take it up after some time, Lordship. Mr. DP Bora is on leave, Lordship.
Other side, you're appearing how?
Well,
You're serious with this contempt matter.
contempt matter, my lord, during the pendency of the contempt case, my lord, they have filed, the state has filed a review petition. Now, my lord, to take review petition.
This is it context of a writ petition,
My lord,
judgment by this court.
my lord.
Okay, after some time. Then who will be coming DP Bora?
DP Bora, Lord.
After
He is on
what?
leave, Lordship, after some time.
What was the judgment about?
My lord,
What was the judgment about?
well, the judgment was that, my lord, the petitioner got the order in favor of him, my lord, for appointment of a medical officer. My lord. And now, my lord, the government has taken a victory that the petitioner does not possess the requisite qualification. My lord. And that qualification, my lord, that was introduced later on, my lord, after the publication of the advertisement, my lord. And that is the 1-year course, my lord. And 1-year course, my
This
lord.
is the Borpeta case.
Yes, yes, my lord. Now, my lord, that course, my lord, which was not in existence, my lord, how a petitioner, and that was also, my lord, in service course,
Okay, let him come.
my lord.
But we have haven't we passed the detailed order here? I vaguely remember Mr. Bora was appearing.
Yes, Lord.
According to you, that qualification was not even mentioned in the advertisement.
My lord.
Isn't it? And later on, they are now
Saying that-
favoring you from appointment, saying that you do not qualify.
Yes,
You
sir.
do not possess the qualification.
And
Okay, let Mr. Bora come.
my lord. Obliged.
Not your lordship. So last occasion, direction was given to take a fresh step, your lordship, but we could not find out the proper address, so we need some more time to take fresh steps, your lordship. Other than respondent number 6, other respondents are not served, your lordship. Only respondent number 6 is
You are
served.
appearing for 6. You need some more time.
Yes, your lordship. 2 weeks more time, your lordship.
Office note dated 1/7/2023 reflect that no fresh steps with proper address has been taken for the respondents except respondent number 6, who has actually appeared in through the 3S not to compare MS Deca, learned counsel for the appellant prays for some more time. List of 3 weeks.
Problem.
May I please, your lord? My lord, in this matter, service is complete, my lord. Your lordship may kindly have a look. Office note dated 16/6/2023, my lord. And also honorable court order dated 19/6/2023. Matter may be listed for admission.
You have appeared for
My lord, I have appeared for respondents number 1267B to 7G.
others have been served.
Yes, my
My lord, the legal heirs of deceased respondent 7A have not appeared. My lord, even though service is complete, they have not appeared as a
7A1.
7A1 to 4, my lord. 7A4.
As per office note dated 16/6/2023, comma. The steps taken by usual process was served and accepted by the respondent number 7 within bracket A, bracket close 1. This side of this connectivity. Who had accepted not only for herself, but other respondents also. However, AD card oblique unserved notice have not been received back. Full stop. Herefore,
My lord, respondent number 1 to 6 and 7B to 7G.
7,
B to 7G.
your name,
G Imtiaz. My lord. G Imtiaz.
G.
appearing-
Imtiaz.
Yes, ma'am.
To G. Imtiaz, Learned Counsel submits that he is appearing for the respondent numbers 1 to 6, comma, 7 within bracket B to 7G.
Yes.
Full stop. Para. Service being complete, comma, this matter for admission after 2 weeks. Full stop. The other respondents who have been served may enter appearance with the message.
Highly obliged.
Lordship, as per office note dated 14/3/23, to AD card in respect of 2 and 3 has not been received back. And LCR has also not been received.
Goswami for R1. The third for has not been received. 43. Office note dated 14/3/2023. Reflect that respondent number 1 has been duly has entered appearance. And in fact, today, we R. Goswami Learned Counsel is present in the court. Full stop. Para. It further states that AD card for respondent number 2 has not been received back, and the note was issued on 14/3/2023. Full stop. LCR has not also been received. Full stop. Para. Office to issue press requisition, issue requisition. Press requisition for the LCR. Full stop. Matter may also be listed before the learned Lozima court for passing appropriate orders on deemed service, and thereafter be listed before this court for orders along with the LCR if received. If received, no, along with the LCR. Along with the note on the LCR.
May I please your lordship? Office note dated 9/5/23 reflects that addressee is not found. That is the respondent number 2. And the LCR of title suit has not been received.
I am appearing for respondent number 1.
Who is two?
Who is Vijit Sharma also?
Not connected to you.
He is not connected. He has sold the land as a power attorney of my vendor and have purchased the land.
He also adduced evidence before the trial court. I'll also take instruction from him.
We have already taken steps on respondent number 2 through newspaper publication in I 4213 public 19.
Is it?
Yes, newspaper is there.
It's completely-
He did not appear.
I,
I had a limitation.
but it was in IA.
Yes.
I will take instruction whether I can appear for him.
Office note dated 9/5/2023 reflects that so far as the service report regarding respondent number 2 is concerned, the same has returned back with a note of the process server within inverted comma addressly not found. Similarly, the posted endorsement is also within inverted comma not found. Your name?
Jedaka.
Error. J. Learned counsel for the appellant, however, submits that there was a similar situation at the time of adjudication, the IA filed for contradiction of delay, in which case the state respondent number 2 had to be served through paper publication, and therefore it may be deemed that the respondent number 2 is aware of this proceeding. Pre-SK Learned counsel for the opposite party number 1. Respondent number 1. He, however, submits that he may be granted some time to take instruction as to whether he may appear for the state respondent number 2. Full stop. Please, after 2 weeks, the
LC also not received.
2 weeks. Full stop. In the meantime, that there be a press requisition for the LCR by the registry of this court. Full stop. Para. In fact, two weeks.
Your Lordship, one I is there for suspension of the execution of decree.
Is there any?
There is no question of suspension of decree. Lordship, they have originally they have claimed right capital interest and cancellation of sale deed in our favor. Thereafter, Lordship, suit was decreed. Suit was decreed
In your favor, in their favor.
Lordship. Thereafter, we preferred appeal. Appeal, the suit was appeal was allowed, suit was dismissed. Their prayer was dismissed. There is no question of execution or anything. Lordship.
Lordship, as per office note dated 27/6/23, Lordship, it has been mentioned that the affidavit which we have filed, Lordship, it is not tagged to the record. So, Lordship, the registry may verify because we have taken the steps on, Lordship.
When did you file the affidavit?
18/7/23, Lordship.
Affidavit.
Yes.
Okay, you son is appearing for
1 and 2. Lordship.
1 and
2.
2. Number.
36.
Your SP Sharma.
Yes, sir. SP son.
SP Sharma, learned counsel, submit, learned counsel for the appellant, submit that step through paper publication was made, whereafter an affidavit was filed on
18/7/23.
18/7/2023 as per order dated 12/5/2023. There is an office note dated. There is an office note that affidavit, that such affidavit has not been received. Obviously, since the affidavit has been filed subsequently, the same was not there on record when the office note was made on 27/6/2023. Please free to verify and tag the affidavit dated 18/7, what?
18/7.
18/7/2023 with the record and list the same after a week. Bless. Pre-app, Leonard Counsel is present for the response number 1 and 2.
Wait, please, no. Followed in this revision petition, my lord, we are challenging the order dated 14/10/2019 at page 23. What happened, my lord, there were 3 MACT claims, my lord, and there were ex parte award passed against the petitioner. Thereafter, the petitioner filed an application under Order 9 Rule 13 for setting aside that ex parte awards. On the date when it was fixed, my lord, it was dismissed for default. We filed an application for restoration. And by this order dated 14/10/2019 at page 23, my lord, the application was rejected and the Order 9 Rule 13 application has also been disposed of. Now, pursuant to this order, my lord, we filed 3 revision petition, my lord. 1 revision petition, this honorable court has already interfered with that order and remanded back the matter for consideration of the Order 9 Rule 13 application on merits.
Take care for
I am for respondent number 5.
claimant. Oh, insurance.
Insurance.
Claimant.
I am for the claim. 1, 2, 3.
All. Contesting is by whom? By Jalan.
Against the owner. Against the vehicle owner.
He is the vehicle owner. No, here in this proceeding, I think Jalan will be the most affected party.
Yes.
What do you say about this order, earlier order?
This order, I'm not aware of this. There are 2 cases. I'm not aware about this other case, pending case, my lord, which has been remanded back. I have to go through this, my lord.
You go through this Wednesday. Normally, MSC cases, in case of non-appearance, you file it.
Firstly, what has happened, ex parte order was passed. I have to, in view of this order, passed by this honorable court. There were 3 revision petitions.
Put it to file. That is the normal procedure. These are not adversarial kind of litigation. Unless fraud or something else is involved. This litigation is only meant for giving benefit. Without there being any misuse or abuse.
Let me go through this order.
Wednesday.
For admission. Lordship can also call for CRP 86 of 2022.
Disposed of matter.
No, the pending one. There is
2 more.
1 more.
There were 3. 1 has been disposed.
1 has been disposed of.
Okay. 3B Kaushik Learned Counsel for the petitioner submit. There submit that initially 3 numbers of CRP were filed and one being CRP number 89 of 2022 has already been disposed of. The other CRP which has not been listed is CRP number
86 of 2020.
86 of 2022. Full stop, para. List on Wednesday next, along with CRP 86 of 2022. Full stop. This, the Learned Counsel for the opposite part for the respondents are also directed to have a look, directed to peruse the final order passed in the disposal of CRP so that an effort can be made to dispose of the remaining 2 CRP in accordance with law. That is the date of the motion.
My lord, I am for the petitioner. Today it has come because of the IA 1001 of 2023.
What is that for?
That
Filed by
was
Samaria.
my lord, filed by Samaria. There was a direction from this court on 24/23 for a police because there was a status quo order. They have filed an application for modification of the order, stating that the construction is going on, though there is a status quo order. So on 24/20/23, there was a direction from this court for a police inquiry. The report has come that there is no construction going on.
Lordship, there are two phases here. First is about the main revision petition. Here, my lord, Lordship can see a note sheet. All respondent have received the notice except respondent number 4. Now, so far,
You
the
are for the respondent number?
1, my lord. I am the principal respondent, my lord. So far, respondent number 4 is concerned, 3 attempts were made, and there is a report coming before this honorable court saying that the address could not be found, my lord. Therefore, that may be treated as a deemed to be sub, my lord. The matter may finally fix for my lord final admission, my lord, for final disposal next week or my lord this week. And Lordship can-
When was notice issued?
My lord, the notice was issued. First was on 21/3/2023. Thereafter 3/4/2023.
You have taken steps twice?
No.
And last also one there is same noting coming.
Now, are you interested or to pursue your IA as present after
Absolutely, my
the?
lord. I am coming to the IA now, my lord. Lordship, so far the IA is there is a very funny thing is going on, my lord. My lord, Lordship, just have a look. On the one side, police is saying no construction is going on. My lord, each and every day they are, my lord, doing the construction. Now, this is the peculiar situation, my lord. How this situation has to be handled, my lord. There is a status quo. The action passed by this honorable court. My lord, we are in a very panic situation, my lord.
The report says the suit property, no construction
There is
going.
not a conclusive part, my lord. I am placing, my lord, recent report, my lord. My lord, photo cannot tell lie, my lord.
The photograph of which date?
But that suit property, my lord.
Which date?
My lord, that the first set of documents are recent last week, my lord.
No, you have to have a date in the photograph.
Anyway, my lord, kindly see the last date also I have given. Where, my lord, after passing the status quo order by this honorable court on 4/4/2023.
Versus what number? So into 12/4/2023.
Report is of 21/6/2023.
This is something very disturbing.
My lord, may I pray, my lord, one thing, my lord.
no.
The order is to be implemented in realism, my lord. Lordship.
Mr. Ashwini, just have a look at this. This has got a date also.
My lord, one thing what I understand, man, because it was on the consent of both the sides, there was a direction for the police to make a report. Police has sent a report on 21/6/23.
Where is the report?
My lord, it is in the report in the last.
In the IA?
Yeah, in IA, my lord, last. Your lordship will find the report is there. I have honor to report that as directed.
Just a minute. Flag P. Flag P. Part 1 file, flag P. Part 1 file. I don't mean to.
I can take it out, my lord.
No,
The blue cover file, my lord.
Part 1 file.
Last one, the next one.
Flag P.
Like the small one, my lord, the small one.
Part 1.
That one. The report is there. Report is there, my lord.
Flag P.
Yes, my lord, it is there in this small file, yes. Flag B is there, my lord. To file the auction?
We'll get it.
To file, that's it. It's so much.
No, it's here. It is here.
here, the
It is
report
here. No, it is here in the main file. With reference to the subject related to the different court. Physically inspected for Magiram Shankar. Who is Magiram Shankar?
Magiram is the petitioner, my lord. And here the Swarnalipi Bora, her name is also there.
No, any construction. Not good. This is the
21/6/2023.
I have also given last week, my lord, photograph.
The photo, what is the date of this photograph?
It is 12/4/2023.
This is of 25/6.
My lord, this is the first photograph. Thereafter, my lord, the police reactions was there. Police visited, submitted the report.
But afterward also, my lord. under
Let
the
there
note-
be a, my lord,
Just let me
individual
complete my
advocate,
submission.
advocate commissioner's report.
Lordship,
Where is the property?
my lord,
Nogam.
No, my lord. Lordship, may I submit only one thing? In IA, my lord, 101, I have specifically prayed before this honorable court, Lordship, that police may be directed to take vigil of that facts and, my lord, restrain all the parties to carry out the concern. That direction till yet has not been given. I think that is the proper thing. And second aspect, my lord, the CRP, my lord, otherwise not maintainable, Lordship, may finally dispose this matter, my lord, whatever outcome will come, my lord, that will be, my lord, applicable to both parties.
I am agreeable to. Let it come for final disposal.
But one party is yet to be served.
My lord,
One party, as you said, is yet to be served.
my lord, then.
We do one thing. We, since the report, so far as usual process is concerned, that is not, that is, from that report it is not discernible whether it has been served or not. But so far as registered post is concerned, we can draw the presumption. We do one thing, we immediately put up before the learned laws in court, let an order be passed on presumption, and let the matter be placed before this court, on which date will take up for final.
Quite.
My lord,
How we can fix the date?
my lord, and the interim order to
Now,
continue.
Lordship, only one thing, so far 101 prayer is concerned, my lord. But if suppose construction is going, on, nothing survive, my lord. Lordship, because I have a specific prayer that the police may be directed. Lordship, just give a one line, my lord. That will serve the
Police
purpose.
cannot be involved in a civil
My
case.
lord, why my learned friend is
No,
objecting?
no, my lord.
That creates a doubt,
That-
my lord.
My lord, that, no, that itself is, my lord,
My lord,
involved
why
in
he is
CRP.
objecting, my lord? He should come with
Police
clean
cannot
hands,
be
my lord.
directed, my lord.
Okay, okay, let not such a serious issue. Let us see your prayer.
My lord, kindly see. 101 IA.
Please to alter, modify the order.
In the premises aforesaid, it is humbly prayed that before your lordship to kindly admit this application and after hearing the parties, be pleased to alter or modify the order dated so and so, so and so. And be pleased to add one more line. The officer in charge of the southern.
Where is that order?
My lord, order is
Was filed in 936.
4/4/2023, my lord.
936.
Yes, my lord.
936.
My lord, my lord, pray for modification of the order 4/4/2020 passed in I number 936.
936. Where is 936? Yes, I got it.
My lord, they are playing with the, my lord, the judicial order. There is no need doubt to that effect, my lord. Very, my lord, I have a very just prayer that proper implementation.
My lord, what they are asking that, my lord, to harass the petitioner through a police.
We are not on that. But are you taking out any construction activity?
No, my lord, no construction is going on. But it is absolutely a lie, my lord. It is outside the, if something is going on outside the suit property, by a photograph, we cannot say that it is the suit property. When the police himself has physically, my lord, then means the police is telling lies. The court, by a judicial order, has passed an order. The court has made a physical verification. If he brings a photograph of something, my lord, outside the High Court premises, there is a construction going on. He will bring a photograph and say High Court has started
Story
construction.
can be created, my lord, so many, my lord. The facts and, my lord, real facts is that, my lord. Construction is going on, there is no doubt to that. If
Outside the
suppose-
suit property,
my lord,
maybe.
if my learned friend will agree to that extent, that police may be directed to implement, nothing will be happen wrong. to
Police
him or
cannot
to
be
me, my
directed
lord.
to be
No, he's saying
implemented.
police cannot, my lord. Who is he to say police cannot, my lord?
Because the CPC does not provide that way. There should be a provision.
CPC, my
It's
lord,
not a
clearly says
CRPC.
the judicial order can be passed to any extent by this honorable court, even after exercise power 151, my lord.
151,
Discretionary power can be
151 is not
Let
that
him
way.
show under
One
which
second, one
provision
second.
it is restrained.
It is not, don't get too much of,
Because, my lord,
My lord, he
under
want-
their
my learned
instruction,
friend want to
there was a
confine the
physical
power of this
verification.
honorable court. Kindly see.
it is not a matter to be hesitated.
My lord, he wants to confine the power of this honorable court. He doesn't know what is the extreme power of this honorable court.
It cannot be that way, my lord. It
That
is not a writ
honorable
petition.
court can travel anywhere, my lord.
No, it's not a writ petition. It is a civil procedure
Let
court.
him show that the power cannot be exercised by
Why
this
should I
honorable
show?
court.
It is
Which
your
one CPC
petition.
is there. Let him show.
One second, let us pass the order. Heard. As summary Learned Counsel for the applicant, whereas P.K. Roy Chaudhary, Learned Counsel, has appeared for the opposite party numbers 1 and 2.
In IA.
We are in the IA only, huh? IA. Huh? The applicant is also the petitioner. in the connected, in the CRP. দুইটা দেখতে CRP. It transfers that along with the CRP, comma, IS Civil 936 2023 was filed, praying for an interim order. And this court, while ordered it 4/4/2023, while 4/4 had passed the following interim order. It took 4/4/2023. Appeal for the grievance of the applicant petitioner is that in spite of passing the state status quo order, comma, the opposite parties are going ahead with some construction activity. And therefore, the present IA Civil 936/2023 was filed for passing appropriate orders. Sri Roy Chaudhary, the learned counsel for the opposite parties numbers 1 and 2, has submitted that this court filed an order dated 16/5/2023.
And earlier to that, 24/2023. 24.
Yes, yes, wide orders dated 24/2023 and 16/5/2023 had directed the officer in charge, comma, Nagaon Sadar Police Station to make an inspection of the suit property and submit a report. He submits that as per office report, office note dated 26/6/2023, comma, such report has been submitted, which is also annexed and retained in the file as flag B. Full stop. It is submitted that as per the state report, which has been forwarded on 25/6/2023, comma, on inspection, comma, no construction work was going on in the suit. He therefore submits that there is no basis for filing of the present IA. Controverting the state submission, comma, Sri Samaria, the learned counsel, has placed before this court certain photographs to demonstrate that construction works are being undertaken by the opposite party. However, those photographs do not bear a date except one photograph, which is of April 2023. The situation which does emerge is, the learned summary accordingly submit that appropriate orders may be passed so that the order of status quo is properly implemented. Para. This court has also perused the record of the ERP, as per which year for 2N.
My lord, I am for the petitioner.
No. In the
IA.
Hi.
I am for Maghiram Das, my lord.
And who is who is to be served? Who is to be served?
Respondent number 4, my lord, in the
And two,
my lord, two also, my lord, notice, my lord, they said that that service has been completed.
no. Well, as per office note dated 19/7/2023, comma. So for a service by user process is concerned, comma. Respondent number 2 has received the notice. 2, 5 and 6 have received notice, while respondent number 4 could not be located in the given address. Para. So far as service by registered post AD is concerned, comma, neither AD card nor unserved notice has been received from respondent numbers 2 and 4. Full stop. Therefore, from the above, comma, service appears to be complete for the respondents except respondent number 4, in whose case neither AD card nor unserved notice has been received back, and such notices appear to have been dispatched on 22/12/2022 as per the office note of state date. This court is of the opinion that since a report from the police has already been furnished that there is no construction activities, and the photograph placed before this court is of, and one of the photographs placed before this court is of a date prior to such report, comma, interest of justice could be served if the main CRP is taken up for disposal by an early date instead of modifying the order, interim order pass. However, to facilitate such disposal, comma, the matter is directed to be listed before the learned Law Jima Court within a week from today, which shall pass the appropriate orders on the deemed service upon the respondent number 4, and thereafter place this case for. Has it been admitted?
My lord, not.
For admission. Admission. Admission expeditiously. It is also observed that on the state date, comma, the entire matter, an endeavor would be made to take up the entire matter for disposal.
The interim order to continue.
So please come prepared.
My lord.
Interim order passed to continue till the next date of this. And advise your client in case he is correct.
Well, my lord, my instruction goes on from the very first day. We are not constructed, and he is a retired teacher. He is unable to do anything.
My retired teacher are creating more problem because they are free, my lord.
Retired teacher are not getting pension. He has
No
got another
pension, no
litigation.
salary. My lord. How to construct?
This is one of the work they are doing.
He is running for his pension. He doesn't have time. I tweeted out.
May I please?
Yes.
Well, we have filed this IA on behalf of the claimant for
MSc appeal.
my lord, for a direction to make a 50% payment of the awarded amount. That was not directed in the earlier. My lord, what happened, lordship, during this period, lordship, the issue involved in this case has already been decided, remanding the matter to the tribunal. The issue is that, lordship, the deceased was a government employee. As per the government policy, lordship, his family member will get the full salary. Accordingly, this honorable court held that the
appeal has been disposed of over.
Can be disposed of, lordship, in view of the judgment, lordship, that is all remanding the matter.
The appeal is already been fixed for hearing. It's already in the hearing.
Which matter has been remanded?
My lord.
Which matter has been remanded?
Different matter.
In
other matter, lordship.
In a different matter.
Yeah, different matter, Lord.
The
Same
issue,
accident over.
no, lordship, the issue was whether there is a loss of income or not, when a deceased was a government employee.
As per government policy lordship, the deceased family
Will get full
receiving full
salary.
salary up to the age of retirement.
Correct.
After that, he will get pension. Accordingly, this honorable court held that there is no loss of income up to the age of retirement. After that, lordship pension will not be deducted. That will be counted. Accordingly, lordship, the matter is remanded to the tribunal for reassessment of the. My lord, this judgment lordship is fully applicable in this case, lordship. Instead of pending this matter, lordship, para 21, lordship. Para 21 up to 25.
Acharya for whom?
I'm for the insurance company.
Appellant.
Appellant, I'm the appellant. Lord.
Oh.
Yeah.
This is your appeal.
It's my,
I was for
Claimant lordship, respondent number 1 to 3.
for release of
50%.
the amount.
My lord.
There was no order for deposit of 50%. They filed the IF for modification of order and release of 50%.
Third, P. Acharya, Planet Council for the appellate, whereas M. Khan is present for the claimant, for the respondent claimant.
1, 2, and 3.
1, 2. Before going to the fact of the case and issue involved, the Planet Council for the parties are in a broad, have arrived at a broad consensus that the appeal can be disposed of without entering into the marriage by an order of remand. And such consensus is on the strength of an order passed by this court dated 6/9/2022 in a similar matter, being amnesty appeal 261 of 2022. Full stop. Para. The instant appeal has been preferred under section 173 of the Motor Vehicles Act 1988 against a judgment and order dated 24/2021 passed by the MACT, learned MACT, Bongaigaon, in MACT case number 27 of 2019. Full stop. Various grounds have been urged in support of the appeal. And the principal ground is that the deceased was a government servant, and upon his death, the claimants who are illegal heirs would be entitled to the full salary till the date of his superannuation. Full stop. Para. It has been submitted that by the aforesaid judgment dated 6/9/2022 referred above, this court under similar circumstances had remanded the matter to the learned tribunal for a fresh assessment and evaluation of the compensation by taking into consideration all the facts and circumstances, including the aforesaid consideration, which would be relevant. Full stop. Para. In view of the above, the appeal can disposed of by remanding the matter for a fresh assessment by the learned MACT Bongaigaon full stop. Parties uh, uh, such assessment would be made without being influenced by any observation made by this court. Such assessment will be made in accordance, strictly in accordance with law and without being influenced by the court, as this court has not made any observation on merit. Full stop. Sarah, the parties are accordingly directed to appear before the tribunal when
Any date, Lordship,
we bring it to the track, then leave it to the tribunal.
yes, Lordship,
On
8th of August.
no, records have to go.
Yes, yes.
On 28th of August, 28 to 8, 28th of August, 2023. From which date the tribunal would take charge of the matter and fix necessary date for disposal, for a fresh disposal. It is needless to state that the earlier award by the judgment and order dated. What is the date?
And updated
Order
20.
2021 is set aside. That has to be set aside. Set aside. The para please directed. LCR has come? No.
Lordship, LCR has come.
And it is directed to send back the LCR immediately and ensure that the same reaches the learned tribunal Bongaigaon before the next date.
Lordship, the statutory deposit, we may be allowed to.
Yes, the appellant insurance company is also entitled for release of the statutory deposit made at the time of preferring the application, which shall be done within a period of 4 weeks from today by the registry. Okay. In view of the
May I please the Lordship, my lord, this review petition has been preferred in respect of an order at page 15, my lord, by which your Lordship directed to consider the case of the petitioner for appointment as medical record officer, my lord.
Page 15.
Page 15, my lord. And that order was passed, my lord, on the basis that because the petitioner contended in the petition that, my lord, the petitioner along with the another candidate, they got timers, and that candidate has been selected for that or something else. So the petitioner remains the lone candidate. So on that basis, your Lordship has disposed of the writ petition, inter alia directing the respondents to consider the case of the petitioner for appointment. Subsequently, my lord, it has come to the knowledge of that, my lord, Annexure 1, page 13, my lord, the original advertisement, my lord. That advertisement stipulates, my lord, page 13, Annexure 1, my lord, of the review petition. After examination of the testimonials and documents of the petitioner, it has come to know that he doesn't qualify in terms of the advertisement, my lord.
Which clause?
Annexure 1, page 13, serial number 6, my lord.
Medical record.
Medical record officer, graduate in arts, /science, /commerce from a recognized board or university with medical record officer training from recognized institute. So the petitioner doesn't have, or he doesn't possess the disqualification. Medical record officer training from recognized institute, my lord. So because of that, my lord, the candidature of the petitioner could not be, he could not be.
Where is the order we had passed?
Order at page 14, my lord. It started at page 14, my lord.
Just duly consider the case of the petition. The direction is to consider for a.
Consider, but otherwise, since these facts were not
Have you
placed.
passed an order?
No, my lord.
Why did you
Thereafter,
pass an order?
yes, my lord.
You should have passed an order. We have considered, but this factor has come into the as an impediment.
Yes, my lord. Then actually immediately on coming to know, we have been advised to defer this review because this fact was not placed before your lordship, my lord. So if your lordship directs, then we'll pass an order, my lord.
But this itself is pending since more than a year.
Yes, my lord.
When was the order passed?
Order was passed on 12/10/2020, my lord.
3 years have passed.
And review was filed on 14/12/2021, my lord. Review petition.
Review file. But this point, is it a valid point? What has fallen from the submission of Mr. Hawk? He says that this was not even there. This course itself was not there at the time of.
Not in Assam, my lord, but otherwise in that case, they should have challenged the advertisement at that point of time, my lord. But otherwise, my lord, now, my lord, if in violation of the advertisement, if he is appointed, my lord, in that case, many other candidates who were simple graduate, my lord, they could have also applied, my lord.
Now, could you have ever made a valid appointment pursuant to this advertisement if there is not a single candidate could have held this course?
No.
Then in that case.
In that case, my lord, but as per this advertisement,
You have issued the advertisement at page 30.
Yes, my lord.
You have put a condition which cannot be fulfilled by anybody.
No, my lord.
You went ahead with the advertisement. You did not cancel it.
Yes, my lord. There may be, because my lord, there may be some person that they have obtained a degree from outside Assam also, my lord. Outside Assam, it was available, my lord.
My lord, this course was for the first time introduced in the year 2017, my lord. For the first time.
Which course? Training
This
course?
is a medical record officer training course.
Introduced when?
2017, my lord. I'll receive page 11 of my affidavit in opposition, my lord.
And this is of September 17.
Yes, my lord. Then how 1 year course can be completed within this? And it is in service course, my lord. Only in
My
service
lord,
candidate can.
in that case, my lord, they should have challenged the advertisement that time. Then, my lord, other candidates
My
also
lord,
could have applied, my lord.
My documents were verified. I was allowed to sit in the entrance examination. After qualifying, my lord, they had never raised this question that no, he did not have this qualification, so you are not eligible, my lord. They had never raised, my lord. After passing this order, my lord, their eyes had opened, my lord. And they knew very well, my lord, because they are the authority of the, my lord, medical education department, my lord.
My lord, normally the
Kindly see this,
procedure is that, my
kindly see
lord.
this, my lord, notification, my lord, page 11, my lord,
Of your affidavit
my lord,
in the review,
review petition, my lord.
where page
11, my lord, and like that's 3, my lord. My lord, may I read, my lord, the 11 portion. Come to subject, my lord. Schedule of Center Bureau of Health Intelligence in service training course for medical record officer, MRO, and medical record technician, MRI during the course of 2017.
My lord,
Yes, sir.
the facts he wants to submit, my lord, it could have been in the writ petition, my lord, but it is a review, my lord.
My lord, I was never rejected on this ground, my lord. Of this, I was never rejected. The only only was that my timer. Why I should challenge this, my lord? And because they knew very well, my lord, that this qualification only can be acquired after appointment.
No,
Because
no.
it is in service course, my lord. Kindly come to page, my lord, page 13, my lord.
one three,
One three, my lord.
1 3,
1 3, my lord. Yes, serial number 1, my lord. Medical record officer, 12 months, 6 months in class training, and 6 months mandatory project work at respective institutions. Essential, kindly see, my lord. The candidate should be employed as grade B or C level and working as medical record technician, oblique medical record clerk, assistant, oblique assistant, MRO, or other group, so and so, at district level, hospital level, so and so, my lord. The applicant should be graduate from a gov recognized so and so. Is essential qualification may be given to already trained MRT if they are suitable candidate. And kindly see the commencement, my lord. In class training from January 1st January 2017 to 30 June 2017, and project work 1st July 2017 to 31st December 2017. Now, how a person can attend this degree? Well, he cannot, my lord. And they had issued that in the October 2017. Here specifically written, my lord, the candidate should be employed as group B on C. And it is in service training course, my lord. They knew very well, my lord.
My lord, this particular notification is regarding for the in-service, but otherwise it is available
They
for
kindly-
others also, my lord.
My lord, several occasion, my lord, this was clarification was got for my lord, from his side, my lord.
If, my lord, this condition would not have been there, suppose, my lord, suppose assuming that that is wrong, but he did not challenge, he participated in spite of knowing that. If now he is selected, my lord, then in that case, my lord, many other persons with the same qualification without MRT training, my lord, they could have also applied, my lord.
they are first thing, they are not before us.
Yes, my lord.
Number 2, you have made the selection. You have not rejected his application.
No, my lord. The process is, he is trying to.
No, did you reject his application?
Yes, my lord.
At the consideration stage?
Yes, my lord.
Where?
My lord.
Let's see. We took rejection order.
At the consideration, my lord, normally what happens, my lord, after the marks, as per the marks, whenever candidate is, my lord, shortlisted, thereafter his documents are verified.
You don't verify documents before you.
No, my lord. No, my lord, because it is online submission, only all the candidates submits it, my lord. Then thereafter, because due to tie of marks, my lord, both the private respondent in the petition and petitioner were, their case was kept on hold, my lord.
Very difficult to digest. that you don't verify. There is a verification process.
No,
Before
after
you make an appointment, you make a detailed verification, it's a different matter.
yes,
But
my lord.
at first, you have to see, there is a checking whether he has got the essential documents or not. Will you allow anybody, a matriculate, to appear in the examination?
Yes, my lord. If on when the
A matriculate, under matriculate, he applies for a post of professor.
no, under matriculate, that cannot be.
Why? There is no verification. You have said there is no verification at the initial stage.
Yes, my lord. That is true.
Do you allow him to appear in the interview?
Yes, my lord. Not interview, only written test, my
Written
lord.
test, you allow, without going through the papers. Don't make such kind of submission.
My lord, assuming that, suppose, my lord, there was
You
some.
show us a rejection order that he was rejected on this ground.
That order has not been passed, my lord, because no, my lord, that's why I have filed, we have preferred a review petition, my lord, before your lordship. And if your lordship desires that order has to be passed, my lord, then I will ask the respondent to pass it.
You did not use your discretion to pass an order. At this stage, we are not going to allow you to pass an order.
Yes, my lord. That's why immediately we filed a review.
We don't find any grounds for review.
But
And
my lord, basic
And since
principle,
we have
my
not
lord,
complied with the order, we'll initiate contempt proceedings now.
no, my lord, basic.
Who is the alleged contemptor?
The basic.
The principal. Superintendent, principal comes superintendent.
Notice has not been issued.
Yes, contempt case
Notice issued.
Yes, sir. After receiving the contempt case, they are appeared. Now they are taking another step.
My lord, the basic principle when any candidate cannot fulfill the eligibility criteria stipulated in the advertisement, how he can be appointed, my lord?
Are we disputing with your proposition? Are we disputing with what you have said?
Yes.
We have not disputed.
No.
What steps have you taken to reject him?
Yeah.
You did not take any step.
No, my lord, because we
You
preferred
contested the writ petition.
No.
This court has almost recorded a consensus.
No, my lord, only on that point, because I was not allowed, I did not get any opportunity to obtain any instruction, my lord. Because only on that point, the projection made by the petitioner that only because of the timer, my lord, his case was not considered. Only on that projection, my lord, your lordship was pleased to dispose of the writ petition. But I was not allowed to obtain, I did not get any opportunity to obtain instruction or any kind of to file affidavit, my lord. Even if assuming that, my lord, the respondents proceeded in a wrong manner by accepting the candidature of the petitioner. But ultimately, my lord, when it has come to the knowledge that he has not fulfilled the conditions as stipulated in the advertisement, so how he can be appointed, my lord?
The advertisement is of the year 2017.
Yes, my lord.
The writ was not disposed of on the motion stage. Respondent number 5 had filed the affidavit.
Yes, my lord.
You were before this court, and you are saying that you did not have the chance to obtain instruction.
No, my lord, because his projection was that only respondent number 5, my lord, they had timers, so respondent number 5 has filed a affidavit stating that he doesn't have any objection if the petitioner is appointed. On that basis, my lord, immediately, my lord, probably without issuing notice also, my lord, that has been disclosed.
Oh, sorry, on page 11, on receipt of notice.
No, yes, on receipt of notice, my lord. My lord, because on that projection only, that only because of the timers, his case was not considered, my lord. And on the my submission regarding that was that if that is the condition, then he may be appointed. But subsequent, my lord, the basic principle, whether the petitioner, if the petitioner can be appointed in violation of the conditions laid down in the advertisement, then no problem, my lord. But that is the main issue, my lord. The respondents also, my lord.
You cannot go into those aspects in a review petition. We are not exercising original jurisdiction. The review jurisdiction.
Yes, my lord. Because these vital facts could not be placed before your lordship at the time of the petition, my lord. Because he did not project that case. His projection was something else, that only because of the timers, his case has not been considered.
We have considered your submission. You have said more than once that time out was the reason.
Yes, my lord.
But while passing the orders, we have taken your views.
Regarding that issue only, my lord.
CP for our learned standing considered also fairly submitted in view of such categorical standards, whereas department may be directed to consider the case.
Yes, my lord.
We have asked you to consider your case. Consider, reject. You have not done so.
Yes, my lord.
This order was of which year? 2020. We're in 2020.
Yes, my lord.
Contempt we have filed affidavit.
No, my lord. After receipt of the contempt notice, my lord, we have preferred the review petition, my lord.
You have not filed affidavit.
No, my lord. The receipt of the notice in the contempt petition, we have preferred the review petition, my lord.
When was notice issued in the contempt matter? 11/12/2020. And you have preferred the review in 2022. Right.
No, 14/12/2021, review has been filed, my lord.
Number the review.
14/12/2020.
1 year after a year,
Yes, my lord.
contempt here, notice was issued on 11/12/2020.
Yes.
11,
Contempt
11, 12.
2020.
Yes, my lord.
We'll dismiss the review. Heard. Three. DP Bora. Learned counsel for the review petitioners who have filed this petition for review of an order dated 12/10/2020 passed by this court in WPC 1036/2020. Full stop. Also heard free as talk learned counsel for the opposite party writ petitioner. Full stop. The writ petition was instituted by the opposite party with regard to a recruitment process. Please have your seat. Recruitment process initiated by an advertisement dated 4/10/2017 issued by the Fakhruddin Ali Ahmed Medical College and Hospital, Borpeta, within bracket herein after the hospital, for appointment on, amongst others, a post of medical record officer. It is the case of the opposite party within bracket hereinafter referred to as the writ petitioner, that he had applied along with other candidates. Full stop. The applications were considered and the writ petitioner was allowed to participate in the same, wherein a written test was held. Full stop. It is the specific case of the writ petition that in the state written test, comma, the writ petitioner as well as the respondent number 5 within bracket, now within bracket, comma, once Sri Bonojit Das had secured the state mark. It was further averred that the state respondent number 5 had no objection if the writ petitioner was given the appointment as in the meantime the respondent number 5 therein was appointed as an assistant teacher on regular basis. Full stop. The respondent number 5 had in fact filed an affidavit in opposition on receipt of notice, and in the state affidavit in opposition, comma, the respondent number 5 had made a categorical averment in paragraph 6, which has been quoted in the order dated 12/10/2020 of this court, which has been paid to be reviewed. Full stop. The case of the petitioner was that since the respondent number 5 had made such categorical statement on affidavit, comma, the case of the writ petitioner for appointment be considered. Full stop. This court had also recorded the stand of the learned standing council of the department in the aforesaid order in the following manner. Page judgment, internet page 3. Accordingly, comma, this court had passed the following direction. Last direction, but in the state direction not having been complied with, comma, the writ petitioner had filed contempt petition on 3/12/2020, which was registered as contempt case within C number 583 of 2020, in which notices were issued and the two respondents have appeared. Full stop. Long thereafter, on 14 December 2021, the present review petition has been filed. Full stop. Tara. Tripura, standing council appearing for the review applicant has submitted, has urged that there are good grounds of review. Full stop. By referring to Annexure 1 of the review petition, it is submitted that the advertisement which was issued had categorically stated that the minimum educational qualification for an applicant, for a candidate to apply for the post of medical record officer was graduate in art, public science, public commerce from a recognized board or university with medical record officer training from recognized institute. Full stop. It is the case of the review applicant that the aforesaid qualification of having medical record officer training is not met by the review petition, by the writ petition, and therefore the order dated 12/10/2020 is liable to be reviewed. Full stop. He submits that offering appointment to a candidate who does not possess the minimum qualification would amount to violation of the conditions of the advertisement itself, and therefore the review as paid for may be done. Full stop. It is further submitted that the writ petition was disposed of at a stage when proper instructions could not be gathered, and therefore this important fact could not be brought to the notice of the court. Full stop. Para. Seriously confronting the aforesaid submission made by the learned standing counsel of the department, three as of learned counsel for the writ petitioner submit that the writ petition itself is not maintainable, as the same has been filed only to circumvent the contempt petition. Full stop. So far as the merits are concerned, the learned counsel has submitted that the ground thought to be projected is not a valid ground at all. Full stop. By referring to the affidavit in opposition dated 24/3/2022 filed in the review petition, the writ petitioner has annexed a communication dated 26/9/2016 issued by the Government of India, Ministry of Health and Family Welfare, to all the directors of various states and union territories. Full stop. He submits that it is by this notification that a 1-year course for medical record officer was introduced, which includes a 6-month in-house, in-class training at centers and 6-month project work at their place of posting. Put up video. We have to continue later. Price for the reference.
Only my prayer, my lord. This item number 52, my lord, there is the case is case was picked for passing interim order, my lord. Since there is a lapse of time, my lord. So can it be on 27, my lord?
We'll give a date, 27th is Friday.
No, Thursday, my lord. Thursday, my lord. My lord.
My lord,
Mr. Bora, we'll dismiss, but we'll give you some liberty.
liberty to pass order, my lord.
We'll do
Yes,
that.
my lord, yes.
But your negligence is there. That is what is
Yes.
causing difficulty. Yeah.
Obliged, my lord.